Students are joining. We'll start in a minute. Hello, good morning, and welcome to Byju's Exam Prep. Yesterday, we initiated a discussion on elections. The very existence of free, fair, and periodic elections is testimony of the existence of democracy in a country. Parvez Musharraf, who was a military dictator in Pakistan, he also organized elections, but those elections were not fair. Even in dictatorship regimes, there are elections. But how can we differentiate a flourishing democracy from a managed democracy? For that, we need to understand if the elections in that country are free, fair, and held periodically over a period of 5 years. Now, for elections, we have various constitutional provisions. Article 324 of the Constitution entrusts the responsibility of superintendence, direction, conduct, and control of all elections, whether it is election to parliament, president, vice president, state legislatures, that is entrusted with a constitutional body known as the Election Commission of India. But when it comes to the elections to the local bodies, Panchayati Raj institutions, urban local bodies, such elections are conducted, organized, and controlled by the respective state election commissions. And these are also constitutional bodies. Then Article 325, it talks about a common electoral roll. That means voter list cannot be separate. Separate voter list for Hindus, Muslims, Christians, Dalits, that cannot happen in independent India. A common electoral roll, and nobody shall be denied inclusion in this common electoral roll only on the grounds of religion, race, caste, or sex. There can be discrimination, but on the grounds of place of birth. That means your voter list in Karnataka, you are a registered voter in Karnataka, but you may not be part of the electoral roll in Uttar Pradesh or Madhya Pradesh. That can happen. On place of birth, on age, there can be a discrimination. All those who are above the age of 18 or above, they can be enrolled, they can be mentioned in these electoral rolls. Similarly, Article 326, it provides for right to vote, universal adult franchise, where all individuals, all the citizens of India, 18 or above, they have the right to vote, and that right to vote is a constitutional right under Article 326. And we discussed Article 327 and Article 328, and I told you that they are mostly similar. Similar in the sense Article 327 empowers the Parliament, and Article 328 empowers the state legislatures. What you can do, you can enact a law. Through this law, what you can do, you can govern the conduct of elections. Parliament has been empowered by Article 327 that you can enact laws, and through these laws, you can govern the conduct of elections in India. And for that, we have Representation of the People Act 1950, Representation of the People Act 1951, which we shall discuss in great detail on Monday. That's when we have the last class on Indian polity. Clear? But state legislatures also have been empowered that you can also pass a law to govern the conduct of elections to your respective state legislatures, provided Parliament has not enacted a law. Since Parliament has already enacted a law which governs the conduct of elections, not just to Parliament, but also to state legislatures. That is why state legislatures have not enacted their own laws for the conduct of elections to their respective state legislatures. Is that clear? Article 329, basically what it does, it bars the interference of courts. The courts are prohibited from interfering where? In electoral matters. And which are these electoral matters? One such matter we discussed yesterday, delimitation, reorganizing the entire country into territorial boundaries known as constituencies. And it was argued that after every census, there should be delimitation, which was conducted in 1952, 1963, 1973. But then it was realized, particularly by the southern states, that you are basically incentivizing bad performance. The southern states have effectively implemented family planning programs, and because of that, they're able to control the population explosion. But when it comes to northern India, the population control is still not effective, it's still not controlled. That is why there should be a limit on delimitation. There should be a ban on delimitation. And Parliament did that in 1976 by enacting a law known as 42nd Constitutional Amendment Act, which prohibited delimitation till the census of 2001. Even if the census is carried out, the number of seats cannot be increased. The number of seats have been frozen till 2026, which means if at all, the number of seats to state legislatures and the parliament can be increased, that can happen only after the census of 2031. Clear? But then we saw the census exercise of 2001, and we saw the delimitation was also conducted in 2002. But this delimitation exercise of 2002 was carried out for two basic purposes: internal reorganization, so that at least, even if the number of seats do not increase, at least within the state, there should be one person, one vote formula implemented, and to provide for increased reservation for the SCs and STs. That is how delimitation was carried out in 2002. The final award of delimitation was given in 2008. So if there is no delimitation till 2001, which mentioned this 42nd Constitutional Amendment Act 1976, then another Constitutional Amendment Act was passed, 84th Constitutional Amendment Act, which said now that delimitation has happened after census of 2001, now there can be no further delimitation till 2026, which means if at all, now delimitation will be carried out. That will happen after 2031 census, and after 2031 census, we can see the increase in the number of seats as well, whether it is to Lok Sabha, whether it is to the state legislative assemblies. But then delimitation exercise was carried out in Jammu and Kashmir, and we discussed why did the court rule in favor of that delimitation exercise. Primarily because since Jammu and Kashmir was reorganized into two union territories, and for union territories, we can increase the number of seats as well. Because this ban on increasing the number of seats is applicable only for the states, not for the union territories. And who said this? The Honorable Supreme Court. Clear? Then we discussed what is the role, what is the function of the Election Commission of India, what is meaning of superintendence, direction, conduct, and control. And there I told you that Supreme Court in Sadiq Ali judgment, Supreme Court in Kanhaiya Lal Umar versus R.K. Trivedi judgment, Supreme Court has said that this phrase, superintendence, direction, conduct, control, it has given a reservoir of powers to the Election Commission of India. Election Commission of India, when it conducts election, when it organizes election, it has to follow the law passed by the parliament. But if the law is insufficient in a given situation, if the law is silent in a given situation, for that, Election Commission of India can use these powers to supplement that law. And that is how election conduct rules were made. That is how Symbols Order was issued by the Election Commission in 1968. And at the same time, the Supreme Court has said that superintendence, direction, conduct, control, this can be used by Election Commission of India only to supplement the law passed by the parliament. This power cannot be used by the Election Commission of India to supplant the law passed by the parliament. And that is how we discussed the case when EVMs were used for the first time in a by-election to Paravarur constituency in Kerala, where the Supreme Court said this election is null and void because the law explicitly talks about holding and organizing elections using ballot papers. You can't supplant the law passed by the parliament by replacing ballot papers with EVMs because EVMs are not provided by the law. And in 1989, the law was amended to provide for elections through electronic voting machines as well. But what is the ambit of superintendent's direction, conduct, and control? Can the president issue an election notification without the dates announced by the Election Commission of India? Can the governor issue an election notification without the dates announced by the Election Commission of India? For that, the matter went to the court. It was a presidential reference. And this presidential reference talked about powers of the Election Commission of India. And Supreme Court said these powers are plenary in character, unrestricted by the executive. So the president and the governor can issue election notification only after the dates are announced by the Election Commission of India. That's something that we discussed yesterday. But this Election Commission of India, we know what are the powers of Election Commission of India, but what is the composition of Election Commission of India? Constitution says under Article 324 that the Election Commission of India shall consist of Chief Election Commissioner and such election commissioners as may be appointed by the President. We have Election Commission of India, a constitutional body created under Article 324, which has the power of superintendence, direction, conduct, and control of all elections in India. But what is the composition of this body? Constitution says the Election Commission of India shall consist of Chief Election Commissioner and such other election commissioners, as many election commissioners as may be appointed by the President. Till about 1989, the Election Commission of India functioned as a single member body. Single member body in the sense, we only had the Chief Election Commissioner, no election commissioners were appointed. Because how many election commissioners can be appointed? As may be decided by the President, as may be appointed by the President. Till about 1989, we had only the Chief Election Commissioner, no election commissioners were appointed. But what happened in 1989? The voting age was reduced from 21 to 18. Then the government realized that since voting age has now been reduced, there are lakhs and lakhs of individuals now who are eligible to cast the vote, which means the job of the Election Commission of India has now expanded. The role has expanded. The functions have expanded. That is why we need to provide more manpower to the Election Commission. And that is how 2 election commissioners were appointed by the president. But after the election was over, these 2 election commissioners were removed. But then something else happened. In 1991, a law was passed known as Election Commission of India, Conditions of Service of Election Commissioners and Transaction of Business Act 1991. This law was later on amended in 1993. And the combined effect of this 1991 law and the amendments made in 1993 says that now Election Commission of India will have Chief Election Commissioner and not more than 4 election commissioners. Because what does Constitution say? The Election Commission of India shall consist of Chief Election Commissioner and as many election commissioners as may be appointed by the president. Now, this law passed in 1991, amended in 1993, it now proposes a limit, imposes a number that the Election Commission of India will consist of Chief Election Commissioner and not more than 4 election commissioners. Not more than 4. That means we can have less than 4 as well, but it can't be more than 4. And right now, the position is that we have Chief Election Commissioner and 2 election commissioners. Clear? All these 3 individuals are appointed by the president. Basically on the advice of the Prime Minister. So the government has the complete say in appointing the Chief Election Commissioner and the election commissioners. Yes, there is a judgment. In Prashant Bhushan case delivered by the Supreme Court yesterday, we will discuss that judgment as well. But first we have to reach to that judgment. And we will take a journey. We will go through a journey and reach that judgment. First, listen to me. These election commissioners and Chief Election Commissioner shall be appointed by the president, basically on the advice of the Prime Minister, because president does not have any discretionary power. Powers are same. Status is same. The status of the Chief Election Commissioner and the election commissioners is the same as that of the judge of a Supreme Court. Role is also the same. What does that mean? That means Election Commission of India, which consists of Chief Election Commissioner and 2 election commissioners, ideally they should take a decision by unanimity. If not unanimity, then there should be majority vote. What does that mean? Election Commission of India, it does not have only the role to organize elections. It also plays a very important role in other areas. Other areas such as disqualification. Other areas such as resolving party disputes. What does that mean? There are some disqualifications. That means a member of the parliament or the member of the state legislature can be disqualified. On what grounds? Mental unsoundness, change in the nature of citizenship, undischarged insolvent, office of profit. We have discussed this when we talked about parliament, when we talked about the members of the parliament. But if the president can disqualify a member of the parliament on these grounds, if the governor can disqualify the member of the state legislature on these grounds, but president and the governor, they don't act on their own. They have to basically refer this matter to Election Commission of India, and they will have to accept the report of the Election Commission of India. Let's say, for example, Jaya Bachchan was to be disqualified on the grounds of holding office of profit. President cannot disqualify Jaya Bachchan on her own. Now the president has to refer this matter to the Election Commission of India. Now, Election Commission of India is a multi-member body. It has a chief election commissioner and election commissioners, 2 election commissioners. Now, they will come together and discuss whether Jaya Bachchan should be disqualified or not. What should be mentioned in this report that we will give to the Honorable President? Ideally, they should take the decision by unanimity, unanimous decision that yes, all the three of us agree that Jaya Bachchan should be disqualified. But if we can't have unanimity, if one election commissioner has one opinion, Jaya Bachchan should not be disqualified. Other election commissioner has another opinion, no, Jaya Bachchan should be disqualified. Now, in this case, they will go for voting. Now, all the three chief election commissioner and election commissioners, they will vote, and whatever majority is obtained, if 2 members say yes, Jaya Bachchan should be disqualified, this report will be sent to the president, who shall act on that advice. Which means it is not that Chief Election Commissioner has additional power, more power as compared to election commissioners. No, they have equal power. It doesn't mean, like in collegium, any advice which is not acceptable to the Chief Justice of India, any name which is not acceptable to Chief Justice of India cannot be sent to the president for appointment. So in judicial appointments, Chief Justice of India enjoys a virtual veto, but that doesn't happen in the meetings of the Election Commission of India. Chief Election Commissioner and the 2 election commissioners, they have equal role, equal power, equal responsibility. The Chief Election Commissioner does not enjoy the veto. But what the Chief Election Commissioner does enjoy is a casting vote. What is casting vote? Just like the casting vote which is available to the Speaker. If there are 100 MPs who are voting in favor of the bill, there are 100 equally important MPs who are voting against the bill. Now there is a deadlock. What will happen to this bill? The Speaker will have a casting vote. The Speaker will vote either in favor of this bill or against this bill just to avoid the deadlock. In a similar fashion, the chairperson of this election commission, the Chief Election Commissioner, will have a casting vote in case there is a tie. In case one MP, one EC says Jaya Bachchan should be disqualified, other EC says Jaya Bachchan should not be disqualified. In this case, the Chief Election Commissioner will have a casting vote just to resolve this deadlock and then refer this matter to Election Commission of India, who shall act on that advice. But something unusual has happened. Unusual? Mr. Hemant Soren, who is the current Chief Minister of Jharkhand, he was also a mining minister in charge of mines. And then as the minister in charge of mines, he allotted a mining block to his own company, which the allegation said is violating an office of profit, because then you are coming under the influence of the executive. Matter went to the governor. Governor referred this matter to the Election Commission of India. Please tell me whether Mr. Hemant Soren should be disqualified on the grounds of office of profit because of this mining controversy. The law is clear. The report of the Election Commission of India shall be binding on the president or the governor, because the law is clear that the president and the governor shall have to act on the report of the Election Commission of India. But Mr. Ramesh Bais, who was the governor of Jharkhand, he has now been transferred to Maharashtra. He is now the governor of Maharashtra. But for 5 months, Mr. Ramesh Bais did not act on this report. This report is confidential. What is the content of this report? We don't know. But we can only speculate that the Election Commission of India had advised, had recommended to the governor, please disqualify Hemant Soren. But the governor has not acted on this report. So something unprecedented has happened, which has never happened in the history of independent India, that the Election Commission's report, which is binding on the president or the governor, when it comes to disqualification petitions, such a report was kept pending by the governor of Jharkhand for 5 months. He did not act on this, and then he was transferred to Maharashtra. Now we have to see what the new governor has to do on this report. Whether he will act on that report or he will keep the matter pending. He will not act on this report at all. But our point is, Election Commission of India does not have the only role and responsibility to organize elections. It also has an additional responsibility to advise the president and the governor when it comes to disqualifications under the constitution. Election Commission of India has another role, and that role is to resolve the party disputes. For example, in the late 1960s, Congress party got split when Indira Gandhi was expelled from the political party. Then Congress party got split into Congress O and Congress J. Congress O means Congress Old, controlled by syndicate leaders. One such syndicate leader was K. Kamraj. Congress J, the president of the Congress party, the new party which was created by Indira Gandhi, the president was Mr. Jagjeevan Ram. So that is Congress J. So how do we resolve this dispute? That is also the power of the Election Commission of India. What is this dispute? For example, Shiv Sena. It's a state political party. It was started in 1966 by Balasaheb Thackeray. Now, it's a recognized political party in Maharashtra. And we will discuss later what do we mean by a recognized political party. Recognized as the state political party, recognized as the national political party. But here, understand that Shiv Sena is a recognized state political party of Maharashtra. It has a symbol, bow and arrow. It has a name, Shiv Sena. Now, if the party is split in the sense, one camp is led by Shri Uddhav Thackeray, the other camp is led by Shri Eknath Shinde. But out of these competing factions, who will get the name Shiv Sena? Who will get the symbol bow and arrow? Because symbol is very important. Those who are illiterate, those who have absolutely no idea how to read and write, they are also voting, but they are voting on the symbol of the political party. So symbol is like a brand. Even if you don't know who is the candidate contesting elections from your political party, but I know that this symbol belongs to that political party I want to vote for, so people vote for the symbol. And symbol has that brand awareness. So symbol becomes very important. Now, who will get this symbol? Who will get this name? That dispute is also resolved by Election Commission of India. How? Election Commission of India takes a look at the organization wing and the legislative wing. What does that mean? Shiv Sena is an organization. President, general secretaries, district presidents, so on and so forth. Now, if there is a split in the political party, that means some office bearers will be owing their allegiance to Eknath Shinde. Some office bearers will be owing their allegiance to Shiv Sena, to Shri Uddhav Thackeray. Now, out of these competing claims, who controls the organization? Who has the majority of the organization members? And for that, Election Commission of India relies on the constitution of that political party. Every political party has its own constitution as well. And this constitution talks about what is the name of the political party, what is the symbol of the political party, who are the office bearers of this political party, how the office bearers are elected or nominated, and who are these individuals who are holding various offices in Shiv Sena. Then if we have this 100 number list, now Election Commission of India will decide out of these 100, who has the majority, whether Shinde faction or Thackeray faction. So first ECI will take a look at the constitution, and this constitution's copy is given to Election Commission of India. Now, by looking at these office bearers, now Election Commission of India has to satisfy itself who controls the organization, who has the majority in the organizational wing of that political party. And then Election Commission of India would look at the legislative wing. Shiv Sena would have representatives in Lok Sabha, in Rajya Sabha, would have representatives in Legislative Assembly and Legislative Council. In this legislature wing, who controls the majority? That faction will be the real faction, and that faction will get the symbol and the name of the political party. Election Commission of India, in resolving this dispute on Shiv Sena, it said we cannot look at the constitution of Shiv Sena. Why? Because the constitution of Shiv Sena was changed in 2018. And when this constitution was amended in 2018, the copy of that change was not given to Election Commission of India. So Election Commission of India has the constitution of Shiv Sena, but that's an old constitution because this constitution has been amended in 2018. But the updated copy of this constitution is not with us. So we will not rely on the constitution. When we will not rely on the constitution, we don't know who are the members of the organization, who are the office bearers of this political party according to this constitution. So we will base our test on the legislative wing. We will see which faction controls the legislature, has the majority in the legislature, whether it is parliament, whether it is the state legislature. And by testing this majority, Election Commission of India realized that the legislative wing, the majority is with the Shinde faction, and Mr. Eknath Shinde would be the leader of Shiv Sena, and this faction of Shiv Sena will get the bow and arrow symbol of Shiv Sena as well. But when it is resolving this dispute, Election Commission of India has Chief Election Commissioner and 2 election commissioners. They would normally take the decision by unanimity, unanimous decision, that all of them agree that the real Shiv Sena is the Shinde faction. But if they cannot come up with unanimity, they can't have a unanimous verdict, unanimous judgment, unanimous decision, then ultimately they have to go for voting. And all the members of Election Commission has equal vote. It's not that Chief Election Commissioner will have a veto or will have more powers. The role, the power, the function, the status of Chief Election Commissioner and the election commissioners is the same. Is that clear? Let's look at something else. Who is this Chief Election Commissioner going to be? And who are these election commissioners which may be appointed by the President? For that, Parliament has enacted a law known as CEC, Miscellaneous Provisions Act. According to this act, Chief Election Commissioner will be appointed by the President, and this individual should be well versed in the administration. But what is this? This is basically a statutory provision. Statutory provision in the sense this is not mentioned in the Constitution. This is mentioned in the law passed by the Parliament. And what is that law? CEC, Miscellaneous Provisions Act of 1951. What does Constitution talk about? The Chief Election Commissioner. Just 3 things, and listen to me carefully. CEC shall be appointed by President. Shall be removed in the same manner and on the like grounds as the judge of the Supreme Court. And the salary, conditions of service, cannot be varied to his disadvantage after the appointment. Constitution talks about only 3 things regarding the Chief Election Commissioner. The Chief Election Commissioner shall be appointed by the President. But President does not have a discretionary power. Basically, President appoints the Chief Election Commissioner on the recommendations of the Prime Minister. Clear? Now, this Chief Election Commissioner shall be removed in the same manner and on the like grounds as the judge of the Supreme Court. What is the manner in which the judge of the Supreme Court is removed? judge of the Supreme Court is removed by President based on the resolution passed by both houses of the Indian Parliament by special majority. In the same manner, you have to remove the Chief Election Commissioner as well. That means Chief Election Commissioner will be removed by the President based on the resolution passed by both houses of the Parliament by special majority. On what grounds? What are the grounds on the basis of which the judge of the Supreme Court is removed? Misbehavior, incapacity. In the same manner, and on the like grounds, you have to remove the Chief Election Commissioner, which means Chief Election Commissioner will be appointed by the President, will be removed by the President based on the resolution passed by both houses of the Parliament by special majority on the grounds of proved misbehavior and incapacity. And the third thing that is mentioned in the Constitution regarding the Chief Election Commissioner is that once you are appointed, after your appointment, your salary, your conditions of service cannot be varied to your disadvantage. Varied to your disadvantage in the sense, if you were appointed for a 5-year term or you were appointed for a 6-year term, after your appointment, we are saying, no, you will continue only for 3 years. Then we are violating the independence of the Chief Election Commissioner. Because the moment Chief Election Commissioner will assert his independence, will independently organize elections without any pressure from the government of the day, then this government can also remove that Chief Election Commissioner. Then where is the independence of the Chief Election Commissioner? We say your salary is 1,000 rupees. And after your appointment, if you're not towing our line, if you're not doing what we want you to do, then we will reduce your salary to 1 rupee. That cannot happen because we have to provide independence to this office of Chief Election Commissioner. And how do we do that? Constitution says your salary, your conditions of service cannot be varied to your disadvantage after the appointment. But if only these 3 things are mentioned in the Constitution, but what is the eligibility of Chief Election Commissioner? What is going to be the tenure of the Chief Election Commissioner? Can the Chief Election Commissioner be reappointed or not? For that, a law has been passed by the Parliament known as CEC, Miscellaneous Provisions Act 1951. And it is this law which says the Chief Election Commissioner shall be appointed by the President. And this individual should be well versed in the field of administration, which means any individual who has 10 years experience in the field of administration. And that is how you will see most of these Chief Election Commissioners, they are senior IAS officers who are well versed in administration, who have more than 10 years experience of working at the central government. Such individuals are appointed as the CEC by the President. The term is 6 years. Where is it mentioned? Not the Constitution, but by a statute, by the law passed by the Parliament. Not eligible for reappointment. That means if I have been appointed as the Chief Election Commissioner, I have completed my 6-year term, I cannot be reappointed as the Chief Election Commissioner. Because then it is, if I do whatever the political party in power is asking me to do, then they will reward me with extension. You are now reappointed as the Chief Election Commissioner. That should not happen. Fourth, your conditions of service, your salaries cannot be varied to your disadvantage except during financial emergency. Both these provisions, be it statutory provisions or be it constitutional provisions, they try to give a sense of independence to this office of Chief Election Commissioner. Clear? But what about election commissioners? Constitution says the Election Commission of India shall consist of a Chief Election Commissioner and as many election commissioners as may be appointed by the President. But then we have a law passed by the Parliament in 1991, amended in 1993, which says there shall be Chief Election Commissioner and not more than 4 election commissioners. Who are these 4 election commissioners? Number 1, appointed by President. Just like Chief Election Commissioner, appointed by President on the advice of the Prime Minister. Removed by President on the recommendation of Chief Election Commissioner. Chief Election Commissioner is removed in the same manner on the like grounds as the judge of the Supreme Court. But how are these election commissioners removed? They can be removed at any point in time by the president, but only on the recommendations of the CEC. That means these election commissioners do not enjoy security of tenure. They can be removed at any point in time on the recommendations of the CEC. If the CEC recommends the president, please remove that election commissioner, that election commissioner may be removed. Not can be removed or shall be removed, may be removed. For example, the then Chief Election Commissioner advised the president, please remove Mr. Naveen Chawla as the election commissioner, but he was not removed by the President of India. So this recommendation of the CEC is not binding on the president. But without the recommendation of the CEC, election commissioners cannot be removed. So if the Chief Election Commissioner advises the president to remove this election commissioner, president may or may not remove. But if the president on his own wants to remove an election commissioner, president cannot remove him without my recommendation. Clear? What is going to be the term of office? 65 years or 6 years? Whichever is earlier. What does that mean? I am 50 years old. I will be appointed as the election commissioner. I will continue whether till 65 years or for 6 years. I will continue for 6 years. That means once I complete 6 years, now I am 56, I am no longer the election commissioner. Why? Because either I should be appointed till the age of 65 or 6 years, whichever is earlier. Which means if I am 62 right now, I am appointed as the election commissioner. I will not remain election commissioner for 6 years. I will remain election commissioner only for 3 more years, because 65 years or 6 years, whichever is earlier, cannot be reappointed as election commissioners. Can be, however, appointed as Chief Election Commissioner, so that the combined term is not more than 6 years. What does that mean? I am appointed as the election commissioner today. What is my term? 6 years, or till I attain the age of 65, whichever is earlier. But let's suppose my term is as the election commissioner for 6 years. After 6 years, can I be further appointed as the election commissioner? No, I cannot be reappointed as the election commissioner. But can I be promoted as the chief election commissioner? Yes. But for that, the combined term of the CEC plus EC should not be more than 6 years. Which means if I'm appointed as the election commissioner today, I remain in office for 3 years. But then chief election commissioner, his term got over. Now I can be promoted as the chief election commissioner. But what is the term of the chief election commissioner? 6 years or 65 years, whichever is earlier. Does that mean I will remain election commissioner for 3 years, then I'm promoted as the chief election commissioner, then I will remain the chief election commissioner for 6 more years? No. If I'm appointed as the election commissioner today, I will remain in office for 3 years, for example. Then if I'm promoted as the chief election commissioner, although the term is 6 years, but I will continue only for 3 years. Why? Because the combined term of the election commissioner and the chief election commissioner should not be more than 6 years. Is that clear?
Not sure I understand.
But something else has happened. The government has the ultimate say in appointing the election commissioners, in appointing the chief election commissioners. The government has the ultimate say in removing the election commissioners on the recommendations of the president, on the recommendations of the chief election commissioner. And at the same time, if you look at all the other constitutional functionaries, if you look at all the constitutional functionaries, whether it is CAG, whether it is UPSC, whether it is president, whether it is the judges of the Supreme Court or High Court, their salaries are charged on the Consolidated Fund of India. But when it comes to the chief election commissioner and the election commissioners, their salaries are made on Consolidated Fund of India, not charged on the Consolidated Fund of India. And now this matter reached the Supreme Court. Prashant Bhushan filed a public interest litigation calling for that there should be a change in the way the chief election commissioner and the election commissioners are appointed. And yesterday, a landmark judgment was given by a 5-judge constitution bench of the Supreme Court. What was the judgment? The Supreme Court said Parliament should pass a law. What Parliament has to do? Parliament will have to pass a law. And what is that law? That law will talk about what should be the eligibility criteria for appointing the chief election commissioner. What should be the eligibility criteria for appointing the election commissioners? The law may decide that the salaries of election commission may be charged on the Consolidated Fund of India. Because the Supreme Court said one way in which you can ask the election commission to kneel before you, one way in which you can destroy the functioning of the autonomous institution called the Election Commission of India is to starve this body of funds. Election Commission of India is not listening to the government of the day. Election Commission of India is independently organizing elections without favoring the ruling political party. What the ruling political party through Parliament will do, it will starve Election Commission of India of funds. So what Supreme Court said, Parliament should pass a law and maybe decide whether the salaries, allowances of the chief election commissioner and the election commissioners should be charged on the Consolidated Fund of India. The law may decide whether the election commissioners should also be removed, just like the chief election commissioner is removed. The law will decide whether and how should the appointment of these election commissioners and chief election commissioner take place. The law will decide. But till the time this law is passed by the Parliament, what we will do, chief election commissioner and election commissioners shall be appointed by the president. But here also the Supreme Court innovated another collegium. After consulting a committee, and this committee will have the Prime Minister, will have the Chief Justice of India, will have the leader of opposition in Lok Sabha. But Supreme Court, there is no leader of opposition in Lok Sabha. In absence of the leader of Lok Sabha, leader of the single largest party, in Lok Sabha. Because the Supreme Court said very foundation of our constitution, which is democracy, which is rule of law, is getting diverted. It is under assault because there are institutions which are meant to promote democracy, which are meant to protect democracy. They are controlled by the executive. How? Election Commission of India is like an umpire. There is a cricket match between the BJP and various political parties. This is a tournament. Who wins the tournament ultimately gets to form the government. But in this tournament, the most important role is to be played by the umpire. Umpire has to be impartial, neither favor one group nor against the other. What if the ruling party chooses who the umpire is? The ruling party has the power to remove that umpire as well. Will this umpire not be biased in favor of the ruling party? It will be. And that will violate free and fair elections, which is part of the basic structure of the Constitution. That will violate democratic structure, which is part of the basic structure of the Constitution. That will violate rule of law, which is part of the basic structure of the Constitution. So what Parliament you have to do? You have to enact a law. And through this law, you decide through this law, how can you appoint election commissioners and the chief election commissioner, so that the government does not have the ultimate power in appointments. Because if the government, the ruling party, has the ultimate power in appointing the chief election commissioner and the election commissioners, then democracy, rule of law, free and fair elections would get violated. So you pass a law. And through this law, you can also decide what should be the qualification of these individuals. Through this law, you can also decide whether their salary should be charged on the Consolidated Fund of India or not. Through this law, you can decide whether election commissioners should be given the same protection as we are giving to the chief election commissioner. That you decide. But till the time you decide, till the time you enact a law, the chief election commissioner and the election commissioners shall be appointed by the president after consulting a committee which will consist of the Prime Minister, the Chief Justice of India, and the leader of the opposition in Lok Sabha. In absence of the leader of the opposition in Lok Sabha, the leader of the single largest party in Lok Sabha. Is this judgment good or bad? Depends on how you look at it. But Mr. Chief Justice of India, do you know that you are also part of a committee to appoint Lokpal? You are also part of a committee to appoint the CBI director. CBI was once called by the Supreme Court that CBI is like a caged parrot. CBI is the caged parrot. It will only speak the language of the ruling political party. Who said this? Not me, the Supreme Court of India. And now the CBI director in 2013, it was decided that will be appointed by the government based on the recommendations of the committee, which will have the Prime Minister, which will have the leader of the opposition, which will have the Chief Justice of India as well. But even then, the allegations against the CBI are such that we can still call CBI as a caged parrot. So what changed because of being part of the appointment committee, Mr. Chief Justice of India? You're violating separation of powers. Please stay away from this. And there are others who say Chief Justice of India is helpless. The Supreme Court is helpless because we cannot afford that the government will have the complete authority to appoint the umpire of the elections. And now appointing the umpire, removing the umpire is also your job. Prashant Bhushan argued before the court that no election commissioner has completed 6-year term. No chief election commissioner has completed 6-year term. And we have seen instances where election commissioners have resigned as well. They were forced to resign. And we had also seen that election commissioners were later on, after their term got over, they were appointed to Rajya Sabha, nominated to Rajya Sabha. One election commissioner, Mr. M.S. Gill, he was nominated to Rajya Sabha by the Congress party after his term as the election commissioner was over. There was another election commissioner, Mr. Lavasa, Mr. Ashok Lavasa, who was argued as the most independent election commissioner of recent times. It is argued that when the decision was to be taken whether Mr. Modi has violated model code of conduct in 2019 Lok Sabha election campaigns, he was the one who said, yes, Mr. Modi has violated model code of conduct. But then against Mr. Ashok Lavasa, his family, his wife, his daughter, they had set up some business, and then there were enforcement directorate raids of authorities, to see whether corruption has taken place or not, money laundering has taken place or not. Ultimately, Ashok Lavasa resigned. When Ashok Lavasa resigned, he was sent as the president of the International Bank. When he was sent as the vice president of the International Bank, all the cases against his family dropped. We don't know what happened to those cases. So were these cases filed just to pressurize the election commissioner to resign from his office? So we have seen that election commissioners, they have not acted independently. Yes, we need to fix this problem, but fixing this problem cannot be by the Chief Justice of India being part of this committee, because your presence did not change anything in Lokpal or in appointing the CBI director. This is like violating the separation of powers, which is also part of the basic structure. But be that as it may, now you would see in newspapers that election commissioners have been given the same security as the chief election commissioner. That is not correct. What the court has said, it is desirable, not directed. If the court would have said it is directed that the election commissioner should also be removed, just like the chief election commissioner is removed, which is just like the judge of the Supreme Court is removed, then it would have been binding on the government. The court has said, 4 judges of the Supreme Court have said it is desirable that the chief election commissioner, that the election commissioners should also be removed in the same manner and the like grounds as the chief election commissioner is removed. There was only one judge, Justice Rastogi, who had said, yes, it should have the same protection as the chief election commissioner. But the court has said only it is desirable, not it is directed. That means everything will depend upon the law passed by the parliament. Until that time the law is passed by the parliament, the chief election commissioner and the election commissioners shall be appointed by the President of India. Any questions? Let me know. Then we will jump to the election process. Election commissioners were even called in a Zoom meeting chaired by the principal secretary to Prime Minister. You're absolutely right. And that is how former chief election commissioner said this should not have happened. Who is the private principal secretary of Prime Minister to call a constitutional body, election commissioners and chief election commissioner, to attend the meeting? And luckily, they did not attend that meeting. No doubt. For the selection of CBI, why there is no law, sir? There is a law. The Lokpal law talks about the appointment of the CBI director should be appointed on the basis of this high-powered committee consisting of Prime Minister, Chief Justice, and Leader of the Opposition. PI is filed by Prashant Bhushan. Yes. Is CJI part of the committee now? Yes. Hung assembly in Meghalaya. So what? You will see in a couple of days, anti-defection law would be assaulted. Members will jump the ship and join the BJP or Mr. Conrad Sangma's party. Okay. Now let's look at the entire election process. Normally, the entire election process, it starts with preparation of electoral rolls. Electoral rolls, that means they need to be changed, they need to be modified just before the election, so that those people who have died, they are removed from the electoral rolls, so that those kids who have now become adults above the age of 18, now they can cast vote, their names are to be included in the electoral roll. We have to see whether those individuals who have taken up the voter ID card of a different state, of a different constituency, They are to be removed from this electoral roll. So the first step starts with the preparation of the electoral rolls, which begins normally 5, 6, 7 months before the election. But the real election process starts when the dates are announced by the Election Commission of India. So in a much publicized press conference, the Chief Election Commissioner and the two election commissioners, they address the media and then announce the dates that on this particular date, we will have the elections. Or the elections can be in multi-phases. Lok Sabha election will be conducted in 9 phases. Legislative Assembly election will be conducted in 1 phase. That means in one go, the entire state will vote. Or in Lok Sabha, since it's a bigger country, a huge, vast geographical area, we cannot hold and organize election in one go in the entire country. That is why we have to split the election process into phases. Phase 1, phase 2, phase 7, phase 9, depends upon the Supreme Court, depends upon the Election Commission of India. As soon as the dates are announced by the Election Commission of India, the Model Code of Conduct comes into the picture. What is this Model Code of Conduct? What is the purpose of this Model Code of Conduct? What are the provisions of this Model Code of Conduct? Is it working well or not? What are the reforms that we can suggest? Let's discuss. But first thing, as soon as the dates are announced by the Election Commission of India, then Model Code of Conduct comes into the picture. And Model Code of Conduct remains in force till the declaration of results. Model Code of Conduct was removed yesterday in Meghalaya, Nagaland and Tripura. Dates are announced. As soon as the dates are announced, Model Code of Conduct comes into the picture. And then there is a formal election notification. Who issues this election notification? President, if it's a Lok Sabha election. Governor, if it's a Legislative Assembly election. Then here in this process, we see campaigning going on. We see drugs being supplied, liquor being given to voters, biryani being given to voters, high-octane election campaigns, people asking for votes in the name of religion, race, caste, class, whatever it is. Riots taking place, political parties throwing mud at each other. Things like that, campaigning goes on. And it is in this process that opinion poll is also conducted and released. And ultimately, then there is voting. After voting takes place, then we have something called as exit poll. After the exit poll, then we have the declaration of results. This is broadly how the entire election process pans out. And we will discuss all these phases one by one. The first is the dates are announced by Election Commission of India. As soon as the dates are announced, the Model Code of Conduct comes into the picture. And what is the origin of this Model Code of Conduct? Just before the first Lok Sabha election was to be conducted in 1951, Prime Minister Nehru wrote a letter to all his cabinet ministers. What was mentioned in this letter? That please separate your official work from the election work. Elections are a costly affair. Costly affair in the sense, I have to go and address rallies in my constituency. For example, this is the constituency I want to contest election from. I have to visit every nook and corner of this constituency to campaign for my election, to canvass for votes, to ask people to vote for me. And when I have to reach to every section of the society, every nook and corner of this constituency, it requires money as well. Money for my travel, for the travel of my supporters. We need vehicles, we need food, we need boarding, so on and so forth. We also need money maybe to provide food to those who participate in the rallies. So elections are costly affair. But imagine I am not a normal candidate contesting the election. I am a government minister. When I am a government minister, I have all the money. I will use the government vehicle to go from one part of my constituency to another part of my constituency. And who will pay the petrol or diesel bill? The government. I have to organize rallies and I will bring people to participate in my rallies, and I will give them food as well. And this food is bought from the money, which is the government money, because I am the minister, I have the money, I have the government money, I have the public money, I have your money. But this advantage is not there for an opposition candidate, which basically violates a level playing field. What is this level playing field? For example, you are participating in a game, or let's say you are participating in a contest. And we say, if you win this contest, we will give you 10 marks. Whoever performs better, 10 marks will be given to you. Now, there are two contestants. 10 marks to you if you do well, 10 marks to this individual if he or she does well. But what if we already say that even before this contest, you have 5 extra marks already given to you? Is there a level playing field? That means even if he or she does bad and he or she gets 5 marks only, crosses 10, and this individual, even if he does spectacularly good, maybe the judges would give 7 or 8 or even 9, but there is no level playing field. In the same fashion, we have various candidates contesting the election. There has to be level playing field. Everybody should have the equal opportunity to contest and win the election. But now this level playing field would get violated if there is a minister who is allowed to spend government money, who is allowed to use the government machinery to campaign for elections. Pandit Nehru wrote a letter to all his cabinet colleagues. Please do one thing: separate your official work from the election work. Which means when you are going for the election rallies, don't take government vehicles. Don't use government officers and take them along with you and campaign for votes. Because if the government employees or if the district authorities, they will go and campaign for you, people will vote for you. Because people will think that if the district authority is with you, if the government employees are with you, then tomorrow when you will be elected, you will have a better chance of taking care of our grievances, taking care of our problems. Don't do that. Separate your election work from the official work so that we can ensure level playing field. And once we ensure level playing field, then we can ensure fair elections. Some people accepted this letter, some people did not, and the elections were conducted. But when the elections were conducted, we realized something else as well. Particularly, it happened in Kerala. And particularly, it happened in West Bengal as well. It happened in Tamil Nadu as well. For example, I am organizing this rally. I'm asking you, Mitro, vote for me. I will give you this, and that. Suddenly, the people from opposition political party or the candidate contesting the election against me, they bring in their guddas and disrupt this rally. When this rally is disturbed, that means I'm not able to convey my ideology to you. I'm not able to convey what am I going to do for you if you will vote for me. What is going to be my policy, my program, and my objective for you? I'm not able to convey this because my rally has been disrupted by my opposition. And when they will organize this rally, I will ask my gundas, you disrupt their rally as well. Then this was happening. Then comments were made, personal attacks were made, which basically lowered the discourse of elections. Then something else happened. What happened? 1960, Kerala government in 1960, it decided that we will partner with all the political parties All the political parties, let's come together, let's have a meeting. And let's agree in this meeting that if you want to campaign for elections, you criticize the political party, you criticize the ideology of that political party, you say what the government has or has not done, but don't level personal allegations against each other. That lowers the discourse. Don't disrupt each other's rallies, because you should also be allowed to campaign for elections. Others should also be allowed to contest elections and campaign for the elections. Let's not disrupt each other's rallies. And the government, you have an additional responsibility. What is the additional responsibility? If, for example, now listen to me carefully, this is the most interesting point. If you have to vote for me, for that I have to give you something, otherwise you will not vote for me. If you like me, you will vote for me. But if you neither like me or dislike me, now you have to decide whether you want to vote for me or not. I have to give you something in the form of a bribe. And that is where the people protest. This is where the people complain that tomorrow after the election, without giving them bribe, these politicians, they don't listen to us. But who started this? They gave you bribe in the first place to vote for them. Now they are just asking for the money back. That tomorrow when you come to us to get your problems resolved, you will have to pay the money back, because this is the investment. We have to get the return on our investment. But be that as it may, the government has a upper hand. Just before the voting, I will announce that every government employee would be given 10,000 rupees extra salary this month. I can do that because I have the money. This is the government money. All I have to do, other political parties, they have to get donations from people, from corporates. That money they can use to spend in these elections. But since I am from the ruling party, I have the access to money. I withdraw money from this fund and tell you that all the government employees, 10,000 extra salary is credited to you, which basically means everybody would love it. It's like 10,000 rupees per vote. Please vote for me. I will win the election. Kerala State Administration invited all the political parties. Can we stick to some minimum code that we all should agree? That we will not disrupt each other's rallies. We will not call each other names. We will criticize each other's policies and programs, but we will not have personal attacks, launch personal attacks on the political leaders. And at the same time, government, you should not create any policy when elections are being conducted. You should not withdraw money from the fund and give it to the people when elections are to be conducted. All political parties said, agree, we will do that. Why? Because today I am in power, tomorrow you can be in power, and you can also violate the same thing. You can also violate the level playing field. So we agree that yes, stick to this. But who agreed? Political parties in Kerala. Nobody forced them. Neither did the High Court, nor the Supreme Court, nor the Election Commission of India. Nobody forced them. It's thanks to these political parties. They have voluntarily decided to come together, and they have decided to follow a minimum code. This was in 1960. And just before 1962 elections, the Election Commission of India circulated this document to all the states. All the states, come here. Look what Kerala has done. You are the same political parties who are contesting elections in other states as well. Take a cue from what is happening in Kerala, where all the political parties, they have voluntarily decided to come together and observe a minimum code. Please, can all the other political parties also do the same in all other states? Why just in Kerala? We will do that in the entire state, in the entire country. And then prior to 1967 general elections, initiatives were now taken by 3 states: Kerala, West Bengal, and Tamil Nadu. This is where Communist Party was very strong. Communist Party, Congress, and others, they decided to come together and said, we will follow this minimum code. Not just in Kerala, we will follow in West Bengal, we will follow in Tamil Nadu as well. Tamil Nadu, in fact, implemented something unique. Tamil Nadu said, it should not only be that you are voluntarily deciding that we will follow this minimum code. We need to set up a committee which can oversee whether all political parties are abiding by this code or not. And a seven members representing seven different political parties. Now you have the responsibility. You have to ensure and you have to oversee whether this minimum code is being followed by all the political parties or not in Tamil Nadu. And when representatives of all seven political parties are together, they will ensure that this minimum code is not being violated. That is what became the origin of the model code of conduct that we see today. Based on this experience that we saw in Kerala, West Bengal, Tamil Nadu, but more specifically in Tamil Nadu, the Election Commission prepared a document, and the title of this document was Appeal to Political Parties for Observance of a Minimum Code of Conduct During the Election Propaganda. And it is this title, it is this code which came to be known as Model Code of Conduct. And this Model Code of Conduct then started implementing from 1979 elections throughout the country. But it was implemented with utmost sincerity. It was implemented with beautiful, meticulous planning by the legendary Chief Election Commissioner, T.N. Seshan. So what is the origin of Model Code of Conduct? As soon as the dates are announced, Model Code of Conduct comes into the picture. And what is this Model Code of Conduct? Pandit Nehru wrote a letter to ministers, please separate election work from official work. What is the purpose? The purpose is to ensure level playing field so that every political party, every candidate contesting the election is in an equal position to win the election and convince the voters to vote for them. And that is how we can ensure a fair election. Because elections cannot be fair if the government has undue advantage, because government has the money, government has the resources, government has the officials. If you want, every election can be won by the government of the day. How? By withdrawing money from the fund and giving it to the people, vote for us. That should not happen. And then a code, an initiative was started in Kerala, then initiative was started in West Bengal, Tamil Nadu, but more beautifully in Tamil Nadu, where all the political parties decided to come together voluntarily. Nobody forced them. Neither the Supreme Court, nor the Election Commission, nor the High Court, nobody forced them. They voluntarily decided to come together. And they have voluntarily agreed that we will abide by this minimum code. And this minimum code became Model Code of Conduct prior to 1979 elections. But it was implemented with utmost sincerity, impartiality by the legendary Chief Election Commissioner, T.N. Seshan. Now let's look at what are the provisions of this Model Code of Conduct. There are some general provisions. General provisions such as no party or candidate shall include in any activity which may aggravate existing differences or create mutual hatred or cause tension between different castes and communities, religious or linguistic. Which means organizing rallies. And in these rallies, you are giving speeches to basically say that these two communities, they cannot live together. We have to destroy them. That would be creating what? That would be creating differences or aggravating the differences that are already present in our society. That is violation of Model Code of Conduct. No political party or the candidate has the right to do that. That's number one. Number two, criticize political parties. But criticize political parties based on what they have achieved and what they have not. What they have promised and what they were not able to deliver on that promise. Don't attack each other personally. So personal attacks should be not included in your speeches. Attack each other's political parties. Not just that. There should be no appeal to caste or communal feelings. All the Hindus should vote for me. That cannot happen. All the Muslims should vote for me. That cannot happen. That would be violation of Model Code of Conduct. Who said this? Political parties themselves. Voluntarily. There is no law which talks about model code of conduct. Is model code of conduct mentioned in Representation of the People Act? No. Is model code of conduct represented in any law passed by the parliament? No. Model code of conduct is a voluntary document. It's created by the political parties themselves. And all of them have agreed that in our activity, we will not do anything which will aggravate the existing differences in our society, whether religious differences or linguistic differences. We will not attack each other personally. We will attack each other's policies, programs, and political ideology. We will not ask for votes in the name of caste or in the name of religion. Similarly, political parties and candidates shall ensure that their supporters do not create obstructions or break up meetings and processions organized by other political parties, something that we saw in Kerala. I am organizing the rally, opposition is disrupting this rally. Now they are organizing the rally, I call my gundas, disrupt their rally so that you cannot preach what you want to promise the political parties, what you want to promise the voters. Similarly, there are strict guidelines for the party in power, because party in power has enormous clout. And if some restrictions are not imposed on party in power, then you will violate the fair elections. You will disturb the level playing field, because the basic purpose, basic need why model code of conduct is in place is to ensure level playing field. The party in power, whether you are in power at center or you are in power in the state, the ministers shall not combine their official visit with electioneering work and shall also not make use of official machinery or personnel during electioneering work. That means if I am a minister, but I have to organize a rally in my constituency, I can't use government vehicle. I have to use my own vehicle. Even if I use government vehicle, I have to pay the government for that election campaign. But Prime Minister is exempted from this because of security reasons. Prime Minister can use the government machinery as well. Government machinery in the sense the government transport as well. But for that, the Prime Minister has to pay the election, pay the government, basically pay himself. That I have used your services, I've used your machinery, now I'm paying you for that. The political parties pays for that. But Prime Minister is exempted. Similarly, government transport, including official aircrafts, vehicles, machinery, shall not be used for the furtherance of the interest of the party in power. This is a polling booth. I have to bring people from their homes to this polling booth. People are saying the polling booth is too far. How will we go? We cannot go. I'm tired. Don't worry. Bring all these government vehicles and one by one ferry, one car per voter. You're driven by a chauffeur, a driver. You sit on the back seat and then go to the polling booth, drop your vote and come back. We will drop you back to your home. So you will feel as if you are the Prime Minister at that time. We will give you government vehicles to go to the polling booth and then come back. The government has vehicles, but the government cannot use, the political party in power cannot use these government vehicles for the furtherance of the interest of the party in power, to bring voters so that these voters can cast vote in favor of the ruling political party. Now, political party in power has money as well. Let's say, for example, the Hindu newspaper. If there is a front page newspaper ad in the Hindu, and we want that this newspaper advertisement should be throughout the country in the sense, there are various editions of the Hindu newspaper, Chennai, Delhi, Bangalore, Hyderabad, so many editions. If you want that your ad should be published in all the editions of the Hindu newspaper, on the front page, the full page, and the back side of the full page, that's known as the jacket ad, it costs 70 lakh rupees. If there is an ad on the top, just on the top, that's what is called Skybus, it costs 16.5 lakh rupees. If there's a quarter page ad just in the Hindu newspaper, it costs close to 24.5 lakh rupees. If it is a Dainik Bhaskar, then it will cost 55 lakh rupees. If it is only in Chennai, it will cost more. So multiple newspapers, different newspapers have different pricing schemes. And if Congress has to issue an advertisement, for every advertisement they have to spend 10, 70 lakh rupees, for example. They will not have that much money. That means they will not on a regular basis, on a daily basis, in all the newspapers carry out advertisements. But government has no such limitation. Government has all the money. So the ruling party, which is the party in power, will issue advertisements that we have done this, these many things. That means advertisement is being carried out in the newspapers, but with the photo, the name of the prime minister or the chief minister. But the payment for these advertisements is released by the government from public money, from your and my money. This should not be allowed. As soon as the dates are announced, when Model Code of Conduct comes into the picture, issue of advertisement at the cost of the public exchequer, at the cost of the public money in newspapers and other media is not allowed. If you do that, that's violation of Model Code of Conduct. Similarly, there are some discretionary grants available. Discretionary grant, that means out of your own discretion. Normally, there is something called grants in aid. We have Consolidated Fund of India. From Consolidated Fund of India, we can give grants in aid. That means to aid your jute industry, some money will be released from Consolidated Fund of India and given to West Bengal. To aid the construction of hospitals in different parts of the country, for that, money can be withdrawn from Consolidated Fund of India and given to the states. But this grants in aid is released from Consolidated Fund of India on the recommendations of the Finance Commission. On the recommendations of the Finance Commission. But then there are some discretionary grants available where the government in its own discretion can give you money, can give money to the state governments. So whenever there is an election in Nagaland, if the central government wants, it can release money from discretionary grant and give to Nagaland for the construction of road, for the construction of hospital during this Model Code of Conduct. It would tantamount to bribing the voters of Nagaland. This is not allowed under Model Code of Conduct. Similarly, no new policies, no new programs can be announced during the Model Code of Conduct, because the idea is, the intention is to provide a level playing field. So what is Model Code of Conduct's origin? We know that it's the initiative of the political parties themselves. They have voluntarily decided to abide by Model Code of Conduct. But what is this Model Code of Conduct? It has some general provisions for all the candidates and parties contesting the election. Don't ask for votes in the name of religion. Don't ask for votes in the name of caste. Don't use mosques and churches and temples for election campaigning. Don't do anything which will aggravate the tensions in our society, whether on religious grounds or linguistic grounds. Don't disrupt and obstruct each other's rallies and programs. If you have to criticize each other's policies, programs, but don't criticize each other as an individual. Don't level personal attacks against each other. But then there are strict guidelines for the ruling political party. The party in power, it cannot mix election work with electioneering work, with the official work. It cannot use government vehicles, government aircraft, transport for election purposes. It cannot use the public money to issue advertisements in the newspapers and other media. It cannot announce new policies and new programs when Model Code of Conduct is in the picture, because then you are bribing the voters. It cannot withdraw money from discretionary fund and give it to the states when Model Code of Conduct is in the picture. So there are general guidelines for all the candidates contesting the election, and there are specific guidelines for the ruling political party. But then it was argued that we need statutory backing to Model Code of Conduct. And what is the statutory backing? Can you be punished? Yes, if you have violated a law. That's what rule of law is. If you have violated a law, only then you can be punished. Clear? What if there is a political party? What if there is a candidate who is violating Model Code of Conduct, but Model Code of Conduct is not a law? It is the voluntary document voluntarily established by all the political parties themselves. So even if you violate this model code of conduct, what action can be taken against you because you have not violated any law? That's how Election Commission repeatedly, for a long time, continuously was asking for a statutory backing. Statutory backing in the sense, mention these provisions in the law. General provisions and provisions for the ruling political party. Mention it in the law so that if you violate this law, action can be taken against you. But over a period of time, Election Commission of India realized that we don't need statutory backing. Why? Because if Model Code of Conduct is given statutory backing, that means it is now a law. Now, what will happen in this case? If you have violated a law, who will punish you? Judiciary. That means the matter will go to the court. And when matter will go to the court is a slow poison. That means if Mr. Amit Shah has violated a model code of conduct, today immediately action is taken by the Election Commission. For example, in 2013, just before 2014 elections, 2014 election campaigning, Mr. Amit Shah was addressing a rally, election rally, and he called for badla. He called for revenge. We will take revenge against the 2013 Muzaffarnagar riots. So for that, you have to vote for me. Election Commission of India quickly sent a notice to Amit Shah. Explain your statement. What are you saying? Badla, revenge. You are doing something which is aggravating the tensions, the differences in our society. Immediately give me a reply. Immediately Amit Shah gave the reply and said, I'm sorry, I will not repeat these things again. Azam Khan also said the same thing. Azam Khan also talked about the same thing. Election Commission sent the notice. Azam Khan replied but did not apologize. Election Commission said, apologize, otherwise we will not allow you to campaign in the elections. Azam Khan still did not apologize. And Azam Khan was banned from campaigning the elections. Quick ban, instant ban. But if it was a law, matter will go to the courts. And courts are a slow poison. We will hear this matter. We will hear this matter. So by the time the grandson of Azam Khan has also violated model code of conduct, then the court will decide. You know, Azam Khan is dead now. Azam Khan in 2014 had violated model code of conduct, and this is the punishment. If model code of conduct is given statutory backing, which means political parties would know that at least for this election, we can violate model code of conduct. If at all action will be taken, that will be taken after 2 years, 3 years, 4 years, 5 years, by the time next election will take place. That is why Election Commission of India is not in favor of giving statutory backing to model code of conduct. Saying if statutory backing is given, then the power of Election Commission of India will be given to the judiciary. Now, Election Commission of India will not be able to penalize those who are violating model code of conduct. And Election Commission of India has said that there are some provisions in model code of conduct which are part of IPC already, which are part of the Representation of the People Act already. Already in the sense, violation of secrecy of voting, causing enmity among communities. Public meetings should be prohibited 48 hours prior to the conclusion of polls. These are all offenses under the Representation of the People Act. So if you are causing enmity amongst the sections of the society, you can be penalized by the judiciary also for violating Representation of the People Act 1951. So it's like twin protection is given. Twin protection in the sense, listen to me carefully. You have violated model code of conduct. If it had a statutory backing, then what would happen? This matter will go to the court and court will take its own time to decide whether you are guilty or innocent. But since it is model code of conduct and it is enforcement is the job of the Election Commission of India, Election Commission of India will quickly take an action. You are banned from campaigning in the elections. We can also register an FIR and you can be arrested. FIR registered, FIR against what? Because these are the offenses mentioned under Representation of the People Act as well. Similarly, Giving bribe to the voters is violation of Indian Penal Code. Threatening voters, threatening candidates, it is basically the violation of Indian Penal Code. It's violation of the Representation of the People Act. So there are some provisions in Model Code of Conduct which are part of Model Code of Conduct as well as part of IPC as well as part of the Representation of the People Act. So now twin protection is given. If a candidate violates Model Code of Conduct, one, action will be taken immediately by Election Commission of India. You are banned from campaigning in the elections. And action can be taken by the judiciary after some time as well, because you have violated the law, which is the Representation of the People Act, which is Indian Penal Code. But what about those provisions in Model Code of Conduct for which there is no punishment provided in IPC? There is no punishment provided in Representation of the People Act. Because withdrawing money from discretionary grant and giving it to the people, it's not a crime in any law. Announcing a new scheme just before the voting is not a crime in any law. Using government machinery to campaign in the elections, it is a corrupt practice under Representation of the People Act. But subtly asking the officials to campaign for you, it's not a crime. And for that, there are some experts who say Model Code of Conduct should be given statutory backing. But there are others who say don't give it statutory backing, because then it will snatch the powers of the Election Commission and vest the power with the judiciary. And judiciary is going to take a lot of time in deciding the Model Code of Conduct violations. But is this Model Code of Conduct working well or not? For that, former Chief Election Commissioner, Dr. S.Y. Qureshi writes. He writes in his book, Elections and Undocumented Wonder. He cites the example of Goa. He said in Goa, elections were to be conducted, dates were announced, Model Code of Conduct comes into the picture. And when Model Code of Conduct comes into the picture, what Mr. Manohar Parrikar did, he advised the governor that appoint this individual who was a candidate contesting the election as a minister. S.V. Qureshi says that I called Mr. Manohar Parrikar, don't do that. I said, why? Because Model Code of Conduct is in the picture. So when Model Code of Conduct is in the picture, you should not announce any new policy, any new program. So if you are announcing a new policy or a program, it would be violating the level playing field. So because it violates Model Code of Conduct, because your political party have voluntarily agreed that we will not violate Model Code of Conduct. S.V. Qureshi writes that Manohar Parrikar became angry. He said, are you trying to say that I give my constitutional right, I give up my constitutional right to advise the governor to appoint a minister just because there is something called Model Code of Conduct? What difference does it make if I'm asking the governor to appoint a candidate contesting the election as the minister? He said it is violating level playing field. Because if there is an individual and there is another individual, both of them were at the same level. They were contesting the election. Now you're tilting the favor in his scale by appointing him a minister. So ultimately people will vote for this individual, thinking that if I vote for this individual, tomorrow he will become a minister and he will continue to best represent us. Mr. Manohar Parrikar was convinced. Mr. Manohar Parrikar dropped the idea and he said, I bow down before the moral code of conduct. I surrender my sovereign right to choose a minister to the moral right of the code of conduct. Something else happened. Dr. S.V. Qureshi writes that since during Model Code of Conduct, no new policy, no new scheme can be launched. Then what happened? The law minister announced a scheme after the declaration of the poll schedule, which means after the dates were announced, which means when the Model Code of Conduct was in the picture. Election Commission advised law minister, don't go ahead with this. You're violating Model Code of Conduct. He did not pay any heed. He went ahead and announced the scheme. Election Commission approached the president and president imposed fine on that minister. And later on, that minister, when he contested the election, he lost the elections. When he lost the election, what does that mean? That means it is not model code, perhaps it is moral code. And whenever you read in the newspapers that a particular candidate has violated model code of conduct, according to Dr. S.P. Qureshi, the people don't look at that candidate favorably. And that candidate, since negative publicity is generated against that candidate because they have violated model code of conduct, it does not sit well with the voters, and voters teach them a lesson. They don't elect these candidates. So it's not a model code. It's basically a moral code of conduct. But is this working well? Is this working fine or not? We saw violations in 2019. We saw violations in Delhi assembly elections in 2020. Mr. Rahul Gandhi said, Chowkidar chor hai. Model code of conduct says criticize each other's policies, programs. Criticize the government on the Rafale, but don't personally attack the Prime Minister. No action was taken. Mr. Modi addressed a rally and said Rahul Gandhi is fighting an election from a constituency where the majority are in the minority. Basically, where the Hindus are in a minority and the minority are in the majority. Basically, the Muslims and the Christians are in the majority. Don't do anything which will aggravate the differences in our society, whether religious or linguistic differences. No action was taken against the Prime Minister as well. In Delhi, two important members. One is now the Information and Broadcasting Minister, Cabinet Minister, Mr. Anurag Thakur. The other sitting MP, Parvez Sahib Singh Verma. They said, Desh ke gaddaron ko, those who are the traitors of this nation, kill them. And immediately after these speeches, there were riots in Delhi. So this is a fit case of sedition. The maximum that Election Commission did, it banned these leaders from campaigning in the election. While ideally FIR should have been filed against them, this is a classic case of sedition, yet no action was taken. And that is why there are experts who say to better implement model code of conduct, we need the same legendary chief election commissioner like that of T.N. Sessions. So the independence of this office is very important. An independent, a man or a woman of upright character who can implement this model code of conduct with great impartiality, that is the need of the hour. Because model code of conduct was working perfectly fine till the judge of this entire, till the empire of this entire election process was in the safe hands, the independent chief election commissioner. But now, since the election commissioners and the chief election commissioner, they seem to be under the grip of the executive, the election commission is unable to effectively implement model code of conduct. So to better implement model code of conduct, we need an upright, independent, autonomous election commission of India. That is model code of conduct. Any questions? Let me know. I promise I will give a break after I take your questions. Don't worry. Only when you complete a topic, then you can give a break. Otherwise, I give a break, then continue from the same topic. It loses the momentum. Sir, then why Indira Gandhi was alleged that she used government vehicles for campaign when she as the Prime Minister had exemption for using vehicles? Exemption, but for that she had to pay. But she did not even accept that I used government machinery. But it was later on proven that she used the government machinery without paying for it. And ultimately, she was disqualified. Sir, in UP election, Yogi ji said 80 versus 20. Is it not violation of model code of conduct? For that, we need, that's what I said. It all boils down to having an independent, autonomous election commission working. Unless and until you have an independent election commission, these things will happen. Model code will be continuously violated and no action will be taken. If election date is announced, the government has to resign to contest elections. No. Election date is announced, the government need not resign, the government continues. Elections will be organized by the Election Commission of India. How CEC will be chosen, appointed? SEC, State Election Commissioner, appointed by the governor on the advice of the Chief Minister. Sir, many political parties say Hindus as a nation. So is it not make Hindus a nation? Is it not violation of moral code of conduct? That's why I said, I think, few days ago as well. In 1996, in Manohar Joshi case, the Supreme Court said Hindutva is not religion. Hindutva is the way of life. So if you are calling for the establishment of Hindutva in India, that is not violation of moral code of conduct. That is not even violation of any law, because Hindutva, according to the court, is not a religion. Then MP and MLA, those who are not ministers, they have to resign in order to contest elections? No, they don't have to resign. I think your question is based on what Mr. S.Y. Qureshi had advised Manohar Parrikar. But that was in a different context altogether. This individual, he was not a minister when the dates were announced for the Election Commission of India. After the dates were announced, he was advised to become a minister. He was recommended for the post of minister. If you were a minister before the model code of conduct is in place, then don't worry, you continue as a minister. But if you are a non-minister and after model code of conduct has come into force, then according to model code, you should not be appointed as a minister. Sir, when will we study pressure group? That will be discussed in governance. Okay, let's take a break and let's meet 8:05, and then we will discuss the remaining provisions regarding elections. See you on the other side of the break. Sir, in one of the recent articles on Hindu, it was told that delimitation exercise in 2026 will be based on 2021 census. But you told the number of seats would increase only after 2031 census. Now, I think either you have not understood that properly or there is a mistake in the Hindu. The delimitation exercise can happen only after 2026, which means it will happen after 2031 census. And 2031 census will be the basis of delimitation. Sir, if Amit wants to contest elections in 2024, then he has to resign from his seat in order to contest elections. No, why? Did Prime Minister in 2019 resign as the Prime Minister before contesting elections? The minister need not resign for contesting elections. Then when there is no statutory backup for model code of conduct, under what provisions the members have been alleging in the court for the violation? For violating Indian Penal Code, for violating Representation of the People Act 1951, which also talks about that you cannot ask for votes in the name of religion or language, that you cannot create animosity in the society on the basis of caste or religion or language. It's for the violation of the laws, not the model code of conduct. Okay. So initially, the dates are announced by the Election Commission of India. As soon as the dates are announced, then model code of conduct comes into the picture, which remains in force till the declaration of results. Then after some time, we have election notification. Issued by the president if it's a Lok Sabha election, by the governor if it's a legislative assembly election. Now, in this election notification, all the details are mentioned. For example, date of filing nomination papers, withdrawal of nomination, scrutiny of nomination papers. When can you file the nomination papers to contest the election? For that, you have to file this nomination paper mentioning your name, the candidate, which is the political party which has set you up as a candidate, how many criminal cases are pending against you, what is your educational background, what is the amount of assets in your name and in the name of your spouse. All these details have to be mentioned in this nomination paper. Previously, you could also have left some of the areas in the nomination paper blank. For example, what is your marital status? You could have kept it blank as well, because you need not fill the entire nomination paper. Some aspects you can keep blank. But then Election Commission said, no, you have to fill all the details that are mentioned in the nomination papers. And that is how prior to 2014, Mr. Modi would mention against his marital status, he would keep it blank. But after 2014, when it was made mandatory that you have to mention and make all the details mentioned in the nomination papers, that is how he said that I'm married. True, not, that's besides the point. But the moot point is for you to understand for the examination, every detail that is mentioned in the nomination papers, the candidate will have to write. The candidate cannot skip any item which is mentioned in the nomination papers. And then you give these nomination papers, submit these nomination papers before the returning officer. Who is this returning officer? If it's a Lok Sabha election, the returning officer is the collector, the district commissioner, or the district magistrate, as he is known as in some states. If it's a legislative assembly election, then this returning officer is the deputy collector. And you also have to subscribe to oath. And that oath is mentioned under Schedule 3 of the Constitution. That is why when we discuss schedules, I told you that in Schedule 3, there is an oath mentioned for the candidate contesting the election, that I will abide by the Constitution. I have full faith in the Constitution. So when this nomination paper I have to file, I have to fill all the details that are mentioned in the nomination paper, and then I have to submit it to the returning officer. That is how you would have seen, for example, when Mr. Modi would submit his nomination papers, he would submit it before the returning officer. And who is that returning officer? The collector of that particular district in which that Lok Sabha constituency falls. Clear? When we say superintendence, direction, conduct, and control of all these elections is vested with this constitutional body known as the Election Commission of India. Now, Election Commission of India has the power. What Election Commission can do? If there is a superintendent of police whom the Election Commission of India feels that is favoring one political party, or if there is a district collector who is favoring one political party, or if there are officials who are favoring one political party, all these individuals, officials can be transferred. By whom? By the Election Commission of India. That means during this entire election process, all these officers who are posted in different districts, whether as police chief, whether as district collector, they come under the supervision of the Election Commission of India. And Election Commission of India can transfer them from one district to another district in the interest of conducting free and fair elections. Because normally, who appoints the district collector? The government. Who appoints the superintendent of the police? The district authority, the state government. But during the entire election process, because superintendent's direction, conduct, control of these elections is vested with the Election Commission of India. Election Commission of India has the power to transfer these officials as well, if free and fair elections are a threat. If there is a threat to free and fair elections, in the interest of free and fair elections, these officials can be transferred by the Election Commission during the election process. But then after you file your nomination papers, and while you file your nomination papers, you also have to give security deposit. Security deposit, for example, 25,000 if you are contesting Lok Sabha election, if you are from general category. If you are from reserved category, 12,500. If it is a legislative assembly election, then for a general candidate, 10,000 is the security deposit for a general candidate. For a reserved candidate, it is 5,000 is the security deposit. But this is security deposit. And what is the security deposit? You enroll in a university. You have to pay the admission fee, but at the same time, you have to deposit security deposit. And once the course is over, this security deposit is given back to you. Similarly, this security deposit is with the Reserve Bank of India, is with the authorities, and this is to ensure that only serious candidates contest the election. I'm serious in contesting the elections. I know I have the support of the people. To encourage serious candidates, you have to give this security deposit. But after the election is over, once the results are declared, this election deposit, the security deposit, is given back to the candidate, provided this candidate scores more than 1/6 of the votes. Of all the votes polled in this district, in this constituency, I have to submit the nomination papers. I have to subscribe to an oath before the returning officer, which is mentioned in Schedule 3 of the Constitution. I have to also deposit an amount, which is known as security deposit. Once the elections are over, the results are declared, then we will see which candidate got how many votes. All the candidates who got more than 1/6 of the total votes, this security deposit will be refunded to them. But those who score and poll less than 1/6 of the votes, their security deposit will not be given back to you, which means you are forfeiting your security deposit. That is how in local language you call it zamanat zabt, or you have forfeited your deposit. And there are those candidates who are unable to score poll less than more than 1/6 of the votes, their security deposit is forfeited. It's not refunded. But then there is a time given for you to also withdraw your nomination papers. For example, in one constituency in Meghalaya, various candidates submitted the nomination papers, but one candidate of the opposition, once the nomination papers were submitted, then the time came for the withdrawal. He withdrew, and ultimately the BJP candidate won the election unopposed. Whether it can be misused or not, that's besides the point, but an opportunity is provided that you can submit your nomination papers. Once the date of submission is over, then there is a date by which you can withdraw your nomination papers as well. And once the nomination withdrawal date is also over, now all those who are left, their nomination papers will be scrutinized. Scrutinized in the sense whether you have filled all these details or not, whether you were indeed a registered voter in this constituency or not, whether there are some cases pending against you and you have not mentioned those cases, whether you have been convicted by a court of law for 2 or more years, which means you cannot contest elections, which means even if you have submitted your nomination papers can be rejected. So you said in Article 329, there is bar to the interference by courts in electoral matters. You discussed one electoral matter, delimitation, but you said there are more electoral matters. What are these more electoral matters? This is one more such electoral matter. Sir, what is this matter? I filled my nomination paper. I did not withdraw my nomination paper. Now the returning officer is scrutinizing my nomination paper. What if this returning officer rejects my nomination paper? I cannot go to the court. That means I cannot contest the election because there is bar on the interference of courts in electoral matter. One such electoral matter is this nomination paper. But then returning officer would reject the nomination papers of opposition and not let them contest the election. Then what will I do? What will the recourse? After the entire election process is over, then the results are declared. Then you can approach the High Court and say, my lord, my nomination paper was wrongly rejected. And if the High Court finds merit in your argument, it can say that yes, your nomination paper was wrongly rejected. Now fresh election will be conducted in that constituency. But why, sir, only after the results are declared? Why not before? Why can't you approach the court as soon as your nomination papers are rejected? Listen to me carefully. There are 60 seats in Nagaland Legislative Assembly. Clear? I am from the Congress party. I know I'm not winning the election. But if I get more time, maybe I will convince the voters that you should vote for me. Election should not be conducted now. Election should be conducted 1 month later or 2 months later. I will get the support from the people. I just need more time. What I will do, I will ask all my candidates contesting the election that you fill wrong nomination papers, because that returning officer will reject your nomination papers. If returning officer rejects your nomination papers, you approach the court. And when you approach the court will take some time to decide your petition, to decide whether it was rightly or wrongly rejected. Then ultimately what will happen? The election will be delayed. Which means if this system happens, then there are elections in 543 constituencies, but in 20, 30 or even 100 constituencies, we can't organize elections because the matter is before the court. So it will only delay the contest of elections, the organization of elections, the holding of elections. That is why the law says, if your nomination papers have been rejected, you can't contest the election. And then once the results are declared, then you can file an election petition in the High Court. Then if the High Court decides that yes, your nomination paper was wrongly rejected, that is how we will organize fresh election in that constituency. If we will start interfering in electoral matters, when the election process is ongoing, when the election process is going on, it will disturb the entire election schedule, which means we will not be able to complete the election process. That is why file an election petition after the result is declared. And once the scrutiny is also done, that is why you see it's not abused, it's not misused provision. Normally, the returning officers, they do not randomly reject your nomination papers. Once the scrutiny is also done, now these are the candidates who are contesting the election. Now they are campaigning for the elections as well. Now today is the voting day. Let's go to the polling booth and cast vote using electronic voting machine. What is this EVM? It is basically a voting system. But any voting system that we use, whether we use electronic voting machine or whether we use ballot paper. What is an EVM? You come to the polling booth, there is an electronic voting machine, you press the button, the vote will be registered, then you can go out of the polling booth. This is a voting system. Or it's a ballot paper, which means you come inside the polling booth, there is a ballot paper given to you, there are names of the candidates contesting the election printed on this ballot paper, there are symbols of the political party to which they belong mentioned in the ballot paper. Now you have to mark your preference, whether your vote is for candidate A or candidate B. Once you have marked your preference and the presiding officer has stamped your vote, now you can drop this ballot paper in the ballot box. Clear? Any voting system that we use must satisfy 4 criteria. Criteria number 1, accuracy. When I'm filling my ballot paper, I know I have marked my preference against the candidate of the BJP. So I'm satisfied. When I'm dropping this ballot paper in the ballot box, I know I have marked the correct option. Clear? When I'm pressing the button on the electronic voting machine, it should be accurate. Accurate in the sense, if I press the button in favor of the Congress, it should indeed register in favor of the Congress. It should not go to the BJP. So any voting system that we use must be accurate. Second, it must be anonymous. Nobody should come to know whom I have voted for. Because if people come to know whom I have voted for, then there can be costs as well. There can be repercussions as well. For example, if this part of the constituency has voted for the Congress, but in this constituency, the candidate of the BJP has won the election, then what this BJP candidate will do will not take into account your problems, maybe pressurize you, maybe penalize you, maybe make you suffer for not voting for this candidate. That is why the best thing about voting system is that it should be anonymous. Nobody should come to know whom you have voted for. So any voting system that we use, 1, should be accurate. 2, should be anonymous. 3, it should be scalable. Scalable in the sense it should be able to handle very large elections. For example, when ballot papers were being used, now these ballot papers are to be counted as well. Counted as well, one by one, they are to be counted. It would take a lot of time. When it takes a lot of time, that means previously, when election results were to be announced, it would take 2 or 3 days for the final results to be announced. Yesterday, the results were declared, and they were mostly by 12 o'clock. We were knowing for sure which party has won, which party has lost. So any voting system that we use should also be scalable. It should be able to cater to very large population and at the same time, speed. Speed in the sense, there is a polling booth and there is a long queue of people waiting for their turn to cast their vote. And now if I also want to cast vote, but I see a long queue, it basically dissuades me not to vote. I want to vote, but it's going to take a lot of time. There's a long queue, so I will rather not vote. But if I know that the voting takes place very quickly, that means it won't take a lot of time for all these people to exercise their vote. I will stay, I will wait for my turn, and I know this turn will come very soon. I will now cast my vote and then come back. Any voting system that we use must have these 4 required characteristics. It should be accurate, it should be anonymous, it should be scalable, and voting systems should produce results very quickly. Previously, we were using ballot papers. And now we are using electronic voting machines. EVMs, I've told you yesterday, used for the first time in 1982, Paravarur or Parur constituency in Kerala. Who is the presiding officer for president's election? By rotation. What is the rotation? For example, if today there is president's election, the Secretary General of Lok Sabha will be the presiding officer. Election next time, the presiding officer will be, the returning officer will be the Secretary General of the Rajya Sabha. So Secretary General of Rajya Sabha, Secretary General of Lok Sabha will act as the returning officer through rotation. That means in this election, the Secretary General of Rajya Sabha was the presiding officer. In the previous election, it was the Secretary General of Lok Sabha. In the next election, it will be the Secretary General of Lok Sabha. So by rotation, the Secretary General of Lok Sabha and Rajya Sabha, they act as the returning officers when it comes to president's election. Clear? But now EVMs were used for the first time in 1982, but the court said this election is null and void. Why? Because law specifically, explicitly talks about holding election through ballot papers. Then in 1989, the law was amended, provided for electronic voting machines. And initially, we were using electronic voting machines in some constituencies, not in the entire country. But slowly and steadily, 1996, 1998, 1999, we started using EVMs in the entire country, throughout the country, in all the constituencies. What are these EVMs? Manufactured by two public sector undertakings in India. One is Bharat Electronics Limited. The other is Electronics Corporation of India. One is based out of Bengaluru. The other is based out of Hyderabad. That means electronic voting machines which we are using today, these are manufactured by whom? Manufactured by two public sector undertakings, Bharat Electronics Limited, Electronics Corporation of India Limited. Done? This electronic voting machine has two units, ballot unit and control unit, separated by a 5-meter cable. This ballot unit is in the voting compartment. This control unit is with the presiding officer. What do we mean by a presiding officer? For example, the entire country is divided into 543 constituencies. Done? So we have 543 constituencies. But a Lok Sabha constituency is very vast as well. How should we allot polling booths? That means in one constituency, there may be 10, 12 or 20 polling booths. Why? Because we have to ensure maximum participation of the people. If this is a large parliamentary constituency and only this large parliamentary constituency has only one polling booth, where all the people, all the voters of this constituency will have to go and cast their vote, it will discourage a lot of people from going to that area and casting their vote. Because one, it is going to take them time. Second, it is going to take them money. Third, it is going to be a very cumbersome process because it will take a lot of time for these people to vote. That is why ideally every 2 kilometers you will have a polling booth to ensure maximum participation of the people. Every polling booth is presided over by an officer known as the presiding officer. Who are these presiding officers? They're basically government school teachers. They're basically government employees. These government employees, they're trained by the Election Commission of India how to use these electronic voting machines. And during the election process, they come under the supervision of Election Commission of India. Forget your work, forget your teaching, forget any government work that you were doing. You are now under the supervision of Election Commission of India. And you are the presiding officer of this polling booth. So I am the presiding officer of this polling booth. And with me is the control unit. And the ballot unit is in the voting compartment. Which means as soon as you enter the polling booth, we check whether you are indeed the registered voter in this constituency or not. Show me your ID. Okay. Is your name mentioned in the voter list or not? That means yes, you are eligible to cast vote in this polling booth. Please come. Now I am the presiding officer. I will press start button. As soon as I press start button, you can go to the voting compartment and you will see the electronic voting machine. You will press the button. The vote will be registered and then you can go. Which means nobody comes to know whom you have voted for. It's completely anonymous. Similarly, one by one, people will come. We will check your ID card. We will check whether you are the registered voter, whether you are allowed to vote in this polling booth. I, as the presiding officer, will press the button. You will go to the voting compartment. You will press the button on an electronic voting machine, and then you will go. This electronic voting machine, the names of candidates are mentioned in alphabetical order. Alphabetical order. First, the name of candidates of national political party, then state political party, then registered political parties, then independents. Which means, for example, if in this constituency there are 10 candidates contesting the election, how will we organize their names on the electronic voting machine? In alphabetical order. But first, we will add the names of those which belong to national political parties. And which are these national political parties? We will discuss slightly later. So first, in alphabetical order, the names of the candidates belonging to the national political party. Then in alphabetical order, the names of the candidates belonging to the state political party. Then in alphabetical order, the names of the candidates belonging to the registered political parties. Then the names of the candidates who are independents. And at the end, there is one button known as Nota. What is Nota? None of the above. Matter went to the court in 2013. My lord, we need maximum participation of people. When we need maximum participation of people, but people are not coming out in large numbers and voting in these elections. My lord, do you know what is the reason? The reason is that there are criminal candidates set up by the political parties. There are corrupt candidates set up by the political parties. So as a voter, if I want to vote, but for whom should I vote? All these are criminals, rapists, terrorists. I don't want to vote for any of them. That is why I don't participate in these elections. If you want such people to also participate in these elections, participate in the voting process, we need to give them an option known as Nota. None of the above. We are not voting for any of these candidates. The court asked, but what will happen because of that? Sir, it will be like a democratic protest. If the votes polled in Nota are highest, or a large number of people opt for Nota, it will morally force these political parties to set up clean candidates contesting the election. Because overwhelming majority of people are saying, we are not voting for any of these candidates. We are pressing the Nota button. Supreme Court said, yes, Election Commission of India, whenever you are designing the electronic voting machine, the last vote should be, the last button should be of none of the above, Nota, none of the above. Matter went to the court last year as well. What was the matter? My lord, what if Nota gets maximum votes? What will happen to the election in this constituency? Because right now, if there are 10 candidates contesting the election, what is the election process that we have? First past the post system, which means you should not get the majority. You should get the highest number of votes. Anybody who gets the highest number of votes is the representative of this constituency. What if Nota gets the highest votes? Does that mean Nota is the representative of this constituency? Nota basically means none of the above. That means nobody is the representative of this constituency. As of now, the position was that even if Nota gets highest votes, who gets the second highest number of votes after Nota? This person, the second highest number of vote getter, will be the candidate, will be the representative of this constituency. Matter went to the court. My lord, if Nota gets the highest number of votes, election should be cancelled in that constituency. Fresh election should be conducted. The Supreme Court rejected this petition, saying elections are a costly affair. When elections are the costly affair, which basically means if Nota gets the highest number of votes and then we have to organize new election, fresh election, it is only going to cost more. We cannot afford that. That is why even now the position is, even if Nota gets the highest number of votes, But who is that candidate who gets the highest number of votes after Nota? That candidate will be the representative of your constituency. But over a period of time, there are question marks raised on EVMs. That EVMs can be hacked, EVMs are hacked, EVMs are not foolproof, and that is why the BJP is winning the election. In fact, Dr. Subramaniam Swamy, in 1998, he said every election where EVMs are being used in any constituency, BJP wins that election. In fact, there was a book released by Mr. GVL Narasimha Rao, who was the spokesperson of the BJP. This book was released by Lal Krishna Advani. He said elections can be hacked. EVMs can be hacked, which means you are hijacking the entire election process. Congress at that point in time said, how dare you question EVM? EVMs are foolproof. And now the tables have turned. Mr. Modi says, Mitro, don't doubt EVMs. EVMs are foolproof. Congress says EVMs can be hacked. Kejriwal says EVMs can be hacked. And whenever a political party loses the election, they don't agree with the result. They say, we have lost the election, but because EVMs were hacked by the BJP. Can EVMs be hacked and not hacked? What are the advantages of EVMs? Let's discuss. Advantage number one. It is environment friendly. Environment friendly in the sense we don't have to destroy lakhs and lakhs of trees to manufacture paper, and this paper will be used as ballot papers. We only use electronic voting machine. Paper cost is saved. It is environment friendly. Advantage number one. Advantage number two, quick results. That means speed. Speed with which you vote. A voter comes, presses the button and then leaves. And then once the votes are to be counted, we take a look at the EVM, we press one button. It will give us the final count. From this polling booth, which candidate got how many votes, which candidate got these many votes. That means the final number is given quickly. That means speed. Speed of voting, speed of counting as well. That's the advantage. Third, invalid votes. Are the things of the past. What do we mean by invalid votes are the things of the past? When ballot papers were being used, for example, this is the candidate, this is the symbol of the political party, and now you have to give your preference. You have to mark your vote. This candidate A, B, C, D, symbol is P, Q, R, S. Now this ballot paper is given to you. You have to mark your preference. And mostly people will make it correct. So my vote is for candidate A. Candidate A, the vote is registered. Now when the votes will be counted, I know for a fact that this person has voted for candidate A. Perfectly fine. But then there were also people, illiterate people, who were not able to understand this. And we can't even train them that you vote like this, because that would violate their secrecy. They would vote like this. And when they voted like this, they dropped the ballot paper in the ballot box. And then when we had to count these votes, now the counter is now in a fix. Is this vote for C or is this vote for B? Now this is an invalid vote. You might say, sir, what difference does it make? There were times in India when in a constituency, candidate A and candidate B, candidate A was the winner and candidate B was the runner-up. The difference between winner and the runner-up was less than the number of invalid votes. That means the number of invalid votes may be 10,000 in that constituency. But the difference between winner and the loser is only 5,000. Which means if these 10,000 invalid votes were basically given to B, then ideally from this constituency, B should have been the winner. But because of these invalid votes, A is the winner. Maybe, hypothetically. So the difference between the winner and the losing candidate, between the winner and the runner-up, is sometimes less than the number of invalid votes during the ballot paper era. Now, there is no such thing as invalid vote in an EVM. You come, press the button, it will be registered. Whether you wanted to vote for the Congress, but it went to BJP, but whatever it is, it went for some political party, it is not invalid. That's another advantage. Fourth advantage, end of booth capturing. You are young, kids basically. You would not know what used to happen in Bihar, UP, Madhya Pradesh, Rajasthan, and others. And in fact, in various states as well. In almost all the states, in one level or the other, at one scale or the other. This is the polling booth. Now we have the ballot papers. Clear? A gunda would come. This polling booth is hijacked. Presiding officer, give us this ballot paper. Ballot papers were given. They would stamp all these ballot papers. They would mark preference on these ballot papers as well. So 1,000 votes polled in favor of Lalu Prasad Yadav. With no offense to Lalu Prasad Yadav, the allegation was Mr. Yadav's gundas would capture the booth. Whether that is true or not, I don't know. Don't lynch me for that. This is just based on the newspaper articles that I've read. Booth capturing was a menace. Now, what can happen in this case? Sir, even now the gundas can come, enter the polling booth, and continuously press the button on the electronic voting machine, which basically means they can cast 1,000 votes in 2 minutes. That can also happen now? No, it cannot. Why? Because number one, as soon as I see a gunda coming from outside and he wants to hijack this polling booth, I, as the presiding officer, will press the stop button. When I press the stop button, EVM will stop functioning. That means you can come and press the button lakhs of times. Nothing will happen. No vote will be registered. Sir, but what if this presiding officer does not have the time to even press the stop button? Then what will happen? The design of EVM is such that 5 votes can be cast per minute. 5 votes can be cast per minute in the sense, even if the gunda comes, presses the button, 1, 2, 3, 4, 5, then he has to wait for 55 seconds. By the time police will come and say, gentlemen, let me take you to Siberia. So this menace of booth capturing has also ended because of the electronic voting machines. So these are some of the most important advantages of EVMs. But can EVMs be hacked? One member of Mr. Kejriwal's party, Aam Aadmi Party, he was contesting an election in Maharashtra. He said, I have lost the election because of EVMs, because EVMs have been hacked. Because any vote that people are pressing the button for, that vote goes in favor of the BJP. Said, how? How can you say that? I contested the election. The number of votes in my favor after the counting process was 0. How is that possible that nobody voted for me? Let's assume for a while that all the people of this constituency, they are the bucks of Mr. Modi. They voted for Mr. Modi. But my family members, they came with me. They voted for me. But the number of votes in my favor is 0. How is that possible? That means the votes of my family members, they have also been diverted to the BJP. EVMs have been hacked. Even if for a while, let's assume that my family members to my face tell me that we are with you, we support you, but even in their hearts, they are the Modi bucks. They voted for the BJP, but I voted for myself. Where is my vote? EVMs can be hacked. But EVMs cannot be hacked. So then what is this gentleman saying? This gentleman is lying. Why? Because EVMs, these are standalone machines. Standalone machines in the sense, there is no receiver, there is no transmitter. What do you mean by hacking? That means a device can be remotely operated upon, which means I have my phone with me, and this phone, if it is with me, but you can remotely operate my phone, that is hacking. You can remotely operate my laptop. That is hacking. That means you can remotely access my data. To access that data remotely, you need that device to be connected to the internet. That means it should have a transmitter and a receiver. EVMs neither have transmitter nor receiver, which means they cannot be connected to the internet, which means when they are not connected to the internet, they cannot be remotely operated. When they are not remotely operated, that means they cannot be hacked. Have you ever heard, you may have heard that my phone has been hacked, my laptop has been hacked, my desktop has been hacked, my server has been hacked. Chinese have hacked the server of All India Institute of Medical Sciences. You must have heard that. But have you ever heard that calculator has been hacked? You would never have heard that because calculators are not connected to the internet. Calculator is just a counting machine. And the electronic voting machines in India, they are like calculators. It is just like a counting machine. You press the button, it will only display the count. Against this button, against this candidate, how many votes were polled? Nothing more, nothing less. They cannot be hacked. But sir, can we design the program in such a manner that we write the code of the software in such a manner, if vote is won, then register against the BJP, else count plus plus. That's how you design C language, whatever it is. I don't know. Even if you do that, for that you should know the sequence of the electronic voting machine. First, the names of the national political parties and their candidates in alphabetical order. Then the names of the candidates in alphabetical order of the state political parties. Which means even if BJP wants to hack the software and have the software in such a manner that it favors the BJP, for that you have to write the code in such a manner that if the vote is registered for serial number 1, it should go to serial number 10. The 10 is the serial number of the BJP candidate. But 10 can never be and always be the serial number of the BJP candidates. Because in one constituency, your alphabetical name, your name may start from A, and in another constituency from the BJP, the candidate name starts from Z. So you cannot design and hack and design the program in such a manner that it favors one political party. And in fact, there are various checks in place. These EVMs, when they are opened for the first time, there are representatives of all the political parties. In presence of them, the EVMs are checked. Please check whether these EVMs are hacked or not. I'm pressing the button. Now I'm counting as well. See if it is matching. And every time it is matching. Even if you might have heard that EVMs have stopped functioning. They may stop functioning, but they cannot be hacked. Then we will replace it with a different EVM. Listen to me carefully. This is the room where all the EVMs are stored. Even the Election Commission of India, forget about political parties. Even the EVM Election Commission would not know this EVM will go to which constituency. They randomly assign polling booths to different constituencies, which primarily means that there are enough checks in place already to prevent any malfunctioning or any misadventure when it comes to the electronic voting machines. So EVMs cannot be hacked. But the point is, there are countries such as United States of America, which have used EVMs only for some states, but not for the entire country. England and France, they have never used EVMs. They say EVMs are untrustworthy. Netherlands spent billions of pounds to design an EVM, but then they stopped that project. They said, no, we can't go ahead with this. Germany, for example, electronic voting machines have been declared by the German court as unconstitutional. Why? Germany, EVMs are unconstitutional. Not because EVMs can be hacked, but because of lack of transparency. Lack of transparency in the sense, I am pressing the button on the EVM. It has been registered. but registered in favor of whom? BJP or the Congress or the Aam Aadmi Party? I don't know. So it lacks transparency, and that is why in Germany, EVMs are unconstitutional. But in other countries, United States, for example, their EVMs are connected to the internet, which means they can be remotely operated upon, which means they can be hacked. But if United States and other countries, they want to use Indian EVMs, they are safe. Why? Because Indian EVMs are not connected to the internet. They act like a calculator. But there is still a problem with lack of transparency. And to enhance transparency of EVMs, we implemented another measure. And that measure is VVPAT. What is this VVPAT? Voter Verifiable Paper Audit Trail. What is this VVPAT? Voter Verifiable Paper Audit Trail. Implemented for the first time in 2013 in Noksen constituency in Nagaland. What is this VVPAT? This is like a printer. So an EVM is connected with this VVPAT machine. What happens? As soon as you enter the polling booth, you press the button on the electronic voting machine, then the screen, VVPAT screen, will display some information for 7 seconds. What is that information? Number one, what is the serial number of your vote? Number two, the name of the candidate your vote has been registered for. Number three, the symbol of the political party. So what happens now to enhance the transparency? As soon as you enter the polling booth, you press the button on the electronic voting machine. Previously, the problem was lack of transparency. I pressed the button, but I don't know whether it went to Congress or it went to BJP or it went to an independent candidate. I don't know. It lacks transparency. Now, as soon as I press the button, there is a screen which will display three things. What is the serial number of my vote? Why is that important? Because I'm the first person to cast my vote, and the serial number says 1300, which means 1299 votes are already there in the system. I would go to the presiding officer, sir, there is a mistake. Okay, stop the election right now, bring in other EVM, bring in other VVPAT. This would be discarded. Transparency. What is the serial number of this vote? Then what is the name of the candidate for which you have voted? Narendra Damodar Das Modi, symbol is lotus. I am happy. After 7 seconds, this information would be cut, printed in the form of a sheet, and then that VVPAT slip will go to the box. But sir, then it violates the basic advantage of EVM, which is environment friendly. I know it does, but for the sake of transparency, that is a small cost that we have to pay. And tomorrow, all these VVPAT slips and the votes in the EVMs will be matched to see whether VVPAT votes and the EVM votes match with each other or not. But this is something which is not happening properly. We randomly select constituencies, we randomly select polling booths from which we, compare the VVPAT slips and the EVM votes. But Supreme Court has mandated that it should happen in every polling booth, in every constituency. It might delay the election results, but nevertheless, that is necessary for the sake of transparency and for people's faith to be restored in EVMs. Because it's all about trust. And when you start trusting, that's why we say sunlight is the best disinfectant. There has to be transparency in the way we operate, the things operate. If the Election Commission of India will ensure VVPAT slips of all the polling booths are matched with the EVMs, because what happens with the EVMs? All the votes that have been polled, now there will come a time when we have to count these votes. So we press the button on the EVM and then it shows the count. For BJP, these many votes. For Congress, these many votes. Let's compare this with the VVPAT slips as well and see if there is a discrepancy. If there is a discrepancy, then VVPAT slips will have precedence over EVM. And that is how people's faith in the system will be restored. But there is still one problem with EVM, which we have not been able to address yet. And what is that problem? EVMs, as they stand today, violate the secrecy of vote. How? What does that mean? Prior to EVMs, we were using ballot papers, right? Papers. Now, all these ballot papers were dropped in the ballot box. Clear? Now, this is a constituency. And from this constituency, there are 20 polling booths. Clear? So we have 20 ballot boxes. How do we count these boxes, ballot papers? All these ballot boxes would be emptied in a big drum and then mixed. And then one by one, those who will count these votes, they will start counting these votes one by one. Which means when I'm counting this vote, I don't know this vote comes from which polling booth. I don't know. Because we took all these ballot boxes, emptied them in a big drum, mixed them, and then one by one, we are counting these votes. That doesn't happen with an EVM. Why? Because this is the place where counting takes place. Yesterday, counting took place. Votes are to be counted, who won, who lost. And in this counting room, there are representatives of all the candidates. Either candidates themselves, they would want to see whether counting is taking place normally, or if there are 10 lakh votes, 1 lakh votes in my favor, but the officer is saying these 1 lakh votes are in favor of the Congress. So somebody has to ensure that you are also counting these votes properly. So either the candidates or their representatives will be part of this counting process. They will keep a check. They will keep a watch whether the counting takes place normally or not. But what happens in this case? Ms. Kiran Bedi contested elections in Delhi in 2015. And when votes were counted one by one, she was in the lead. And then suddenly she lost. When she was asked, why did you lose? How did you lose? She said, I was leading from all polling booths. But when the votes from few polling booths were counted, I started trailing, and that's how I lost. She gets to know exactly which polling booth is voting for her. How? Because their members are part of the counting room. All these votes are counted EVM by EVM. That means first this EVM will be counted. Press the button, it will show us the count. And these people would know this EVM is from which polling booth. This EVM is from which polling booth. That means the people, they get to know who has voted for you, who has not. Which segment of your constituency has voted for you, which segment has not voted for you. Which means if Kiran Bedi would have been elected, maybe she would have victimized the people of that polling booth which did not vote for her. So EVMs as they stand today, they go against the secrecy of the vote. They violate the secrecy. So then what is the solution? Solution is same as that of ballot paper era. So in ballot paper era, what were we doing? We were taking all these ballot boxes, emptying them in a drum, mixing the drum, and then start counting the votes. So how can we place EVMs in a drum and mix it? All these EVMs from one particular constituency, for example, all these EVMs should be connected with one machine known as totalizer. So all these EVMs which are used in that particular constituency, connect them to one machine known as totalizer. So what this totalizer would do, it would be like a drum. It will take input from all these EVMs and will give the final count. Final count after counting all these EVMs. What is the final count of the BJP candidate, Congress candidate, Aam Aadmi Party candidate, Mayawati's candidate, Benji's candidate, Didi's candidate, anybody's candidate? So this way, the secrecy of the vote will not be violated. Repeatedly, Election Commission is asking that please let's implement totalizer. But the political parties are adamant. Political parties are saying no, totalizer should not be used. Why? Because political parties say these totalizers go against their objective of booth management. Booth management in the sense, as a political party, I want to know from this constituency which are those pockets which are not in favor of me, so that I can persuade them tomorrow. It's not only about victimizing them, it's also about persuading them, so that I can send more people from my political party to them, convince them, tell them that this is our objective, give them benefits, give them drugs, liquor, biryani, whatever it is, so that I can convince them that they should vote for me. If we use totalizers, that means the government, the political party will not be able to analyze the election. Where did they lose? Where did they falter? Where did they win? So for booth management, they need this idea, they need this information. We don't want to know how individual voter is voting, but we need to know how that group is voting, how the members of that polling booth are voting. That is important for our booth management. But the better reform should be if totalizers are totally implemented. That completes our discussion on EVMs. Any questions? Let me know. Sir, why are using EVMs in president and vice president elections? We are not using EVMs in president or vice president's election, or even using EVMs in Rajya Sabha elections. Why? Because there we follow a complicated process. In EVM, you press the vote, but you don't give preference, that your preference is for candidate A, candidate B, candidate C. Our EVMs are not designed that way. Our EVMs are designed to only handle first past the post system. Our EVMs are not designed to handle proportional representation system, single transferable vote. That is why for these elections, EVMs are not used. How many candidates can contest from a constituency? N number of candidates, hundreds of candidates, 200s of candidates, any number of candidates. There is no limit. Election should be free. Anybody who is eligible should contest the elections. In fact, from Nizamabad constituency in Telangana against Mr. KCR's daughter, there were 200, 300 farmers who contested the election. Any number, there is no limit. Okay. One more aspect. What has also happened is that voting percentage is down. And there is one big reason for this less and less number of people coming out to vote: migration. Migration, internal migration. Internal migration in the sense, I am from Karnataka, but I am from Bidar. Now I'm in Bengaluru. If I have to vote, my name is there in the constituency in Bidar. Since I'm working in Bengaluru, how will I go back to Bidar and cast my vote? Shouldn't there be an option that I can vote in Bengaluru remotely for Bidar constituency? Not just this. I am from Bihar, but I am now working in Maharashtra. Elections are in Bihar, but I am in Maharashtra. Who will buy a bus ticket, train ticket, or air ticket to travel to Bihar just for one day to cast the vote and then come back? And these are disincentives. This is what dissuades people from voting. And that is why we see voting percentages less. Allowing these migrants to vote remotely. If you are working in Maharashtra, you can vote in Maharashtra, but for the elections in Bihar. If you are working in Karnataka, Bangalore, but your vote is in Gulbarga or Bidar or Raichur or Bellary or Hassan or Tumkur or whatever, you can vote remotely for your constituency while sitting in Bangalore. And for that, there is remote electronic voting machine, which can cater to, at the same time, 72 constituencies. 72 constituencies in the sense that I am a registered voter in Bihar. Let's say this is a Lok Sabha election, and we have to vote for Bihar elections. But in Bihar, there are 40 seats, 40 constituencies. Now there are migrants from Bihar in Karnataka. All those migrants should be given the option that you vote on this electronic voting machine, and you can choose from up to 72 constituencies. You decide where are you voter. You are a registered voter in, let's say, Patna constituency. So Patna constituency, these are the candidates. You decide whom you want to vote for. So this remote EVM will cater to 72 constituencies at the same time. An election commission invited various political parties. Please come and we will show you a demo. We will give you a demo, a demonstration how this remote EVM will work. Political parties, with the exception of the BJP, objected. Said this is not the right time for remote EVM. First, you have to ensure that people's faith in the existing EVM is substantiated. First, you have to ensure that the election process is fair, so that election commission is independently carrying out superintendence, direction, conduct, control of elections. Once that confidence we have, then we can go ahead with remote EVMs. Right now, we don't want remote EVMs to be implemented because first you have to enhance your own image, your own credibility, your own impartiality. But whether remote EVMs will be used or not used, how they will be used, what is their structure, that we will discuss once the remote EVMs are implemented. Any discussion now on remote EVM would only be academic in nature. That's why once it is formalized, finalized, we will discuss remote EVMs. But this is the idea of a remote EVM. Sir, if the number of contestants are more than the button on EVM machines, how will it be managed? You can have more EVMs connected to each other. So if the number of candidates are more, you can add more devices. So that from 4, 5 EVMs, that's how it happened in Nizamabad constituency, where multiple EVMs were used with different names in different EVMs. That's not a challenge. Is there a limit to the number of candidates? Is there a limit to the number of candidates contesting the election? No. Is there a limit to the number of candidates, those who can be accommodated in a single EVM? Yes. But then even that is not a limit because you can add more EVMs. You can add more EVMs as it was done in Telangana. That is not a challenge. What is remote EVM? Please tell. And what was I telling right now? I was discussing remote EVM. That means you are in Bihar, but you are basically from Maharashtra. Now elections are in Maharashtra. You are in Bihar. You don't need to go to Maharashtra to contest, to vote for the elections. Even at your place, remotely, you can vote for your candidate. Okay, that's about EVMs. Now let's discuss previous year's question papers. And then previous year's question papers are done. We will meet on Monday. And Monday, we will discuss what is opinion poll, what is exit poll, what is compulsory voting, what are the electoral reforms required, what is the Representation of the People Act 1950, 1951. That we will discuss on Monday. Let's now take a look at the previous year's question papers. Okay. Local self-government can be best explained as an exercise of 63% students are right. This is the leaderboard. Local self-government can be best explained as an exercise in democratic decentralization. That is what was recommended by Balwant Rai Ji Mehta as well. Federalism, yes, because federalism means allocation, distribution of legislative subjects, powers between two or more layers of the government, more levels of the government. But when we say local self-government, it's basically that the state are giving up their powers and giving these powers to the local governments. So instead of power being centralized, it is power being decentralized, powers given to the local governments. So it's an exercise in democratic decentralization. Consider the following statements. The minimum age prescribed for any person to be a member of Panchayat is 25. Panchayat reconstituted after premature dissolution continues only for the remainder period. What is the right answer? Sir, for introducing why ECI needs agreement from political parties, they do have powers under Article 324 of the Constitution. Yes, they do have these powers, but you can't force yourself. You can't thrust your opinion on political parties. It has to be done through consensus. Once there is consensus, then it is better implemented, and you can have faith. You can see people will have faith in your system. Everything should be done through consensus, not through force. The minimum age prescribed for any person to be a member of Panchayat is 21 years. So this is incorrect. A Panchayat reconstituted after premature dissolution continues for the remainder period. If the term of the Panchayat is 5 years and it is dissolved after 2 years, then if fresh election is to be held, this Panchayat will remain only for the remainder of the term. This is correct. So 2 only, B is the right answer. This question was asked in 2019 with reference to Constitution of India. Consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India. Which of these statements are correct? What's the issue with A, B, C? My dear, no High Court shall have the jurisdiction to declare any law to be constitutionally invalid. This is incorrect. What did I tell you about High Courts? They can hear all types of cases. In fact, the first Constitutional Amendment Act was triggered by the Patna High Court judgment, where Patna High Court said that Zamindari Abolition Act, Land Reforms Act is unconstitutional. So High Court will have the jurisdiction to declare any central law as also unconstitutional. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India. Incorrect. Why? Because judicial review. What is judicial review? Judicial review is part of the basic structure of the Constitution. Simple terms is EWS reservation, which was an amendment to the Constitution. Was it not challenged before the court? 99th Amendment, which called upon NJAC, was it not challenged and struck down by the Supreme Court? So any amendment of the Constitution can be inquired into the Supreme Court of India. So D, neither 1 nor 2 is the right answer. This question again was asked in 2019. I'll give you 30 seconds for this. With reference to the Constitution of India, prohibition or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which of the following? Now, students are confused between A and C. A and C. Article 142 deals with Supreme Court. Supreme Court can give any order so as to give complete justice. So it is not Election Commission. It is not financial emergency. It is not D. It is Supreme Court. This power is plenary in character. Supreme Court can give any order so as to give complete justice. That's how Article 142 was used in Ayodhya case. That's how Article 142 was used when two judges of the Supreme Court removed Mr. T. Sham Kumar as the Minister of Manipur government, invoking Article 142. We've discussed that. (2019) question. I'll give you 30 seconds, but first I had to read it myself. So long, the motion to impeach a judge of the Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha. Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior. The details of the process. If the motion for the impeachment of a judge is taken up for voting, the law requires the motion to be backed by each of the parliament supported by a majority of total members, not matched by 2/3 of the members present voting. Sir, but you said we use the term impeachment only for the president. The mistake has been made by UPSC, so don't hold me accountable. We use the term, despite what UPSC may say, we use the term impeachment only for the president, not for any other constitutional functionary. 52% students are correct. The motion to impeach a judge of the Supreme Court cannot be rejected by the Speaker of the Lok Sabha. Incorrect. Motion was sent to the chairperson of Rajya Sabha. Rejected this motion to remove Chief Justice of India, Justice Deepak Misra. That's why I told you the presiding officer has the discretion. Either you can admit this motion or you can reject this motion. You can refuse to admit this motion. So that is the power. That's the discretion of the Speaker. The Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges of the Supreme Court of India. Constitution only says the judges of the Supreme Court and High Court shall be removed by the President based on the resolution passed by the Parliament on the grounds of proved misbehavior and incapacity. But what is this proved misbehavior or incapacity? It is not defined in the Constitution. It is explained where? In the Judges Inquiry Act of 1968. So this is incorrect. The details of the process of impeachment of the judges are given in the Judges Inquiry Act, correct? And this resolution, which is passed by both houses of the parliament, which is basically a statutory resolution, which becomes binding on the president to sign, to accept, it should be passed by not less than 2/3 of the members present and voting, plus majority of the total membership of the house, which basically means special majority flavor 2. So this is correct. 3 and 4. C is the right answer. Okay. Question 17. In India, judicial review implies the power of judiciary to pronounce upon the constitutionality of laws and executive orders, the power of judiciary to question the wisdom of the laws enacted by the legislature, the power of the judiciary to review all the legislative enactments before they are assented to by the president, the power of the judiciary to review its own judgments given earlier in similar or different cases. Very simple question, 15 seconds for you. What is the right answer? Tell me. Why? D and B is where students have confusion. Okay. D and B. The power of judiciary to question the wisdom of the laws enacted by the legislature. This is where you may be confused with due process of law, right? In a given question, if there are one, two, or even three statements which appear to be correct, then what you have to do, you have to mark the most appropriate answer. Even if you think that two statements are correct, out of these two statements, you have to mark only one. That should be the most appropriate one. And the most appropriate one is A, the power of the judiciary to pronounce upon the constitutionality of laws and executive orders, whether the laws are constitutional, whether the laws are unconstitutional, whether the actions are constitutional. That's judicial review. But sir, isn't this power of judiciary to question the wisdom of the laws enacted by legislature according to due process of law? But in the original constitution, procedure established by law was mentioned, where you can't go behind the intention of the legislature and question the wisdom of the legislature. Even if we follow procedure, due process of law, even then we don't question the wisdom of the legislature. What we do, we say that this law should be fair. You are acting impartially. You are acting in your wisdom, perfectly fine. But the law should be fair. Law should be just. The procedures mentioned in the law should be fair and reasonable. So even there, we don't question the wisdom of the parliament. We basically want that the law should be just. And that's judicial review. That's due process of law. The power of judiciary cannot review a bill. Judiciary can only review a law, an act of the parliament. So the power of judiciary to review all legislative enactments before they are assented to by the president, which means a bill. Bill cannot be reviewed by the judiciary. Why? Because the judiciary has to review something substantial. What if this bill is passed by the parliament, but the president has not signed this? And if we decide that this bill is unconstitutional, but the president is not signing this, we are wasting our time. Let this bill become an act, then we will challenge it. Clear? The power of judiciary to review its own judgment, that is known as a revisory jurisdiction. Yes, judiciary has the power to review its own judgment as well. That's revisory jurisdiction, 100% correct. But that is not what we call judicial review. Judiciary is reviewing actions of legislature, actions of executive. That is basically judicial review. In revisory jurisdiction, we are just revising our judgment to see whether there is a miscarriage of justice or not, to see if new facts have emerged in that case or not. Judicial review primarily is A. So A is the right answer. Okay. The power to increase the number of judges in the Supreme Court of India is vested in. Now, if you get this question wrong, I will leave the class. And I will give you 30 seconds. Because this is the simplest of all the questions asked. If you get this wrong, I'm leaving the class. It's a threat, but I have no other option. You're making mistakes today. Even then, people have made mistakes. 23% students are wrong. 65% are correct. The power to increase the judges in the Supreme Court. There shall be Supreme Court headed by the Chief Justice of India with not more than 7 judges. Who can increase the number of judges? Parliament, my dear. And increase the number of judges, Parliament can do by simple majority. And I told you I will leave this class at 9:30. Okay. Power of the Supreme Court to decide disputes between the center and the states falls under its what jurisdiction? Again, this very simple question. Very easy question. Original jurisdiction, appellate jurisdiction, writ jurisdiction. What's wrong with you, man? 61% students are right. The power of Supreme Court to decide disputes between center and the states falls under original jurisdiction. You can file these cases only in the Supreme Court. Advisory jurisdiction is president referring a matter to the Supreme Court asking the advice. That's not a federal dispute. Appellate jurisdiction is filing an appeal against the High Court order in the Supreme Court. Writ jurisdiction is for the enforcement of fundamental rights. C is the right answer. Please read the questions carefully. Now, this is something that you have to tell me. If you get this wrong, you're gone. Right to vote and to be elected in India is a fundamental right, natural right, constitutional right, legal right. Thank God, 72%. It is a legal right as well. That means the right provided by the law. But more specifically, what law? Constitution. So it's a constitutional right under Article 326 of the Constitution. Question number 17. Consider the following statements. In the election for Lok Sabha or State Assembly, the winning candidate must get at least 50% of the votes polled to be declared elected. Okay. According to the provisions laid down in the Constitution of India, in Lok Sabha, the speaker's post goes to the majority party and the deputy speaker goes to the opposition. Read this question carefully. Which of these statements are correct? Some students confused with 1, 2. Okay. First is absolutely wrong. In an election to Lok Sabha, winning candidate must get at least 50% of the votes polled. We follow first past the post system, which means whoever gets the highest number of votes is the candidate. We're not talking about majority. Highest number of candidates. First past the post system. According to the provisions laid down in the Constitution, Constitution does not talk about that speaker will be from the ruling party, deputy speaker will be from the opposition party. Constitution only says after the general election, the House of the People, the Lok Sabha, will elect 2 of its members, one as speaker, the other as deputy speaker. It is the convention that we have been following, that the speaker's post will go to the ruling party or the coalition, deputy speaker should go to the opposition. But it is not laid down in the Constitution. Incorrect. D. Neither 1 nor 2. Question 16. The Parliament of India acquires the power to legislate on any item in the state list in the national interest if a resolution to that effect is passed by Lok Sabha, Rajya Sabha. 3 seconds to go. %39% students are saying A and B. My dear, sometimes logic and common sense is very important. When Parliament of India acquires the power to legislate on any item in the state list, Who protects the interest of the states? Rajya Sabha. So 1 and A and B is immediately discarded, eliminated. And Rajya Sabha should pass this resolution. And we have discussed this multiple times. There is a special power available with Rajya Sabha under Article 249. If the Rajya Sabha passes a resolution by majority of not less than 2/3 of the members present and voting, Article 249. D is the right answer. Which one of the following suggested that governor should be an eminent person from outside the state and should be a detached figure without intense political links or should not have taken part in politics in the recent past? This is also something we have discussed. 10 seconds for you. Very simple question. Tell me what's the right answer. Very good. 87%. It is the Sarkaria Commission of 1983. Clear? 2021. In India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies. In 1991, Shri Devi Lal contested from 3 constituencies. As per the existing rules, if a candidate contests in one Lok Sabha election from many constituencies, although we have not discussed this, so we'll discuss this in the next class. Even if you want to know, in India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies. This is incorrect. There is a law, Representation of the People Act, which says you can contest from up to 2 constituencies, from up to 2 seats. In 1991, Shri Devi Lal contested from 3 constituencies. This is correct. But then the law says only 2 seats. This law was changed in 1996. Till 1996, there was no such limit. You could have contested from many constituencies. And that's how Shri Devi Lal contested from 3 constituencies. But the law was changed in 1996. As per the existing rules, if a candidate contests in one Lok Sabha from many constituencies, his party should bear the cost of by-election. Incorrect. B2 only is the right answer. If Mr. Modi contested from Varanasi as well as from Vadodara, you can't represent 2 constituencies. You can contest from 2 constituencies, but you have to give up 1 constituency. He gave up Vadodara. But then to conduct next election in Vadodara, BJP will not pay the money. The money will be paid by us, by the people. That is why 3 is incorrect. Mains-based questions. Judiciary. How far do you agree with the view that tribunals curtail the jurisdiction of ordinary courts? In view of the above, discuss the constitutional validity and competency of tribunals in India. The same questions answer we discussed yesterday, where the question was the High Court's jurisdiction has come under relentless attack. And we discussed Madras Bar Association verdict. We discussed the Tribunals Reforms Act of 2021. Same thing you have to write here. Critically examine the Supreme Court's judgment on NJAC with reference to appointment of judges in higher judiciary. Critically examine. In the sense, you have to mention arguments in favor of NJAC judgment, arguments against NJAC judgment, and then give a conclusion. Arguments against the judgment is independence of judiciary, which judiciary said is part of the basic structure, is not getting violated by NJAC because there are other provisions which maintain integrity and independence of the office, such as they hold office during a well-defined tenure, they don't hold office during the pleasure of the president, they can punish people for contempt, they can be removed only after a complicated process of removal, their salaries and pensions are charged on Consolidated Fund of India. These provisions in the original constitution gave independence of judiciary, and these provisions were not snatched by NJAC. So NJAC judgment is bad in law, but you can also praise it, saying we saw the interference of executive, where executive was interested in committed judiciary and superseding senior judges and appointing their own men as the chief justices. This process had to come to an end. And if NJAC does not give primacy to the chief justice, which violates the basic structure. That is why NJAC was rightly struck down. In NJAC, there are only 3 judicial members, but there are 3 non-judicial members, Prime Minister and 2 eminent persons, the Law Minister and 2 eminent persons. That is why it tilts the balance in favor of the executive. That is why it violates independence of judiciary. But then a compromise. For the larger transparency in the system, the collegium system as it exists today should be modified. That means we can bring in law minister also in collegium meetings. Collegium meetings in the sense, yesterday Faizan Mustafa wrote a beautiful article in the Hindu newspaper. Collegium is recommending a name, government is not accepting. Government is then sending back the recommendation saying these are our objections. Instead, get these objections right at the start. Ask law minister to also come and let's participate in the meetings. And ultimately, when law minister participates in the meetings, take the majority. So there are 5 judges, there is 1 member of the executive. Whatever 5 judges will decide, that will be recommended to the president for approval and appointment. So let's bring in the views of the executive right when we are starting the consultation. That would be the reform. What was held in the Kolo case? In this context, can you say judicial review is of key importance among the basic features of the Constitution? Kolo case, the validity of the 9th schedule was challenged. All laws placed in 9th schedule before 24th April, there is no judicial review. Laws placed in 9th schedule after 24th April 1973, there shall be judicial review, which means judicial review has now emerged as one of the most important key features of the Constitution. You can cite judicial review also by mentioning Kyoto Holohan case, where Supreme Court said, yes, Speaker will take the decision on disqualification, but subject to judicial review. So judicial review, because of various judgments, have appeared as part of the basic structure of the Constitution. Starting from inventing the basic structure doctrine, the judiciary has played a highly proactive role in ensuring that India develops into a thriving democracy. In light of the statement, evaluate the role played by judicial activism in achieving the ideals of democracy. Focus on democracy. Judicial activism, ADR case, right to know the antecedents of candidates contesting the election. That is also your fundamental right. Right to fly the national flag is also a fundamental right. Right to freedom of press, which is one of the 4th pillar of democracy, is also the fundamental right. All these are justifying the achievement of democracy, and all this became possible of judicial activism. Then you can write in 1-2 lines what is judicial activism, the tendency of the court, the urgency of the court. That is what judicial activism is. From local government, these were the questions asked. The reservation of seats for women in the institutions of local self-government has had a limited impact on the patriarchal character of the Indian political process. Sarpanch Pati, something that we were discussing in local government. Assess the importance of panchayat system in India as part of local government. Apart from government grants, what sources the panchayat can look out for financing development projects? What are the sources? They can impose tax. They can impose toll. But they are not doing that. Why? Because they feel, how can we impose tax on our own people? Although they have the power, but they are not utilizing that power. But Consolidated Fund of India can be used to strengthen the finances of the Panchayati Raj institutions. Consolidated Fund of the state can be used to strengthen the finances. Grants in aid can be provided to strengthen Panchayat. Discretionary grants should be used. Similarly, property tax, which is imposed by urban local bodies, can be given to the Panchayati Raj institutions as well, so that they can, through these taxes, generate revenue, so that they can become self-governing institutions, so that they are not dependent upon the state government for funds. The local self-government in India has not proved to be an effective instrument of governance. Critically examine the statement and give your views to improve the situation. They have been elected, but they are not proven to be effective when it comes to governance. For that, they need to be trained well. For that, they need to be funded well. For that, they should be empowered to legislate on these matters, to make schemes for these matters, which are mentioned under Schedule 11 of the Constitution, which talks about these 29 items. But the state legislatures have been hesitant in providing these powers and decentralizing these powers to Panchayati Raj institutions. The suggestion could be the word may, which is mentioned in the Constitution. The state legislature may transfer these funds, transfer these powers to the Panchayati Raj institutions. This may shall be replaced by shall. Then there should be an element of social audit. All these you will have to write in your answer. Question number 4, in absence of well-educated and organized local level government, panchayats and samitis have remained mainly political institutions and not effective instruments of governance. So basically same answer in a different wording for question number 4 as well. There are some questions on elections, but we will discuss them on Monday. On Monday, the last class, we will discuss elections. And once the elections are over, we will also take a look at some of the chapters that you can skip from M. Lakshmikant. Is that clear? Sir, why in previous question paper termed the word impeach for Supreme Court judge? They made a mistake. That's okay. Even previously, we saw one question where I think it was on money bill, where the question said money bill if it is substantially amended by Rajya Sabha. So the first line was wrong. Later on, they changed it, recommendations. UPSC can also make mistakes. UPSC chapter that will be discussed in governance, because in governance there is a topic known as role of civil services in democracy. So there UPSC, State Public Service Commission, Joint State Public Service Commission will be discussed. Okay, then see you on Monday, but please take part in these weekly tests. Very important for you to get the grasp of these topics. See you on Monday, 6 o'clock. Till then, have a great time. Have a great weekend. Bye-bye.